Morning, everyone. Please take a seat, and there's no need to stand for us. It's dark in here. Can you see? I just feel like it's a bit dark right over our desk. We might just see if we can get that sorted. I think, yeah, if we could get the lights switched on. Okay. Now, why isn't my second screen working? Sorry, everyone. I'm just getting my text sorted out. That's better. No, it still doesn't want to work.
The text in here was that they can't turn those on without using phone.
Oh, okay. Well, then I guess we'll just adapt. Amy or Sarah V, can someone just help me? My second screen is not working and I sort of need it. If someone could just give me a quick hand. It was working this morning. Maybe I've got, is there another port? There, another port. Yep. Leave it all there. Okay. Good morning, everyone, and welcome to the hearing for the Viva Liquid Natural Gas Import Terminal, Supplementary EES. Can everyone hear me okay? Sandra, I'll just get you to give me a nod if you can hear me okay online. Okay, great. All right, I'd just like to start the hearing today by acknowledging the Wurundjeri people, the traditional custodians of the land on which we're meeting today, and the Wadawurrung people, who are traditional custodians of the land and seas that we'll be discussing through this process. I acknowledge their deep and continuing connection to their country and their care for the land, seas and sky of their country over many thousands of years, and pay our respects to Wurundjeri and Wadawurrung elders past, present and emerging, and to any other First Nations people who might be joining us through this hearing. I just wanted to remind the parties that we are recording this hearing, so the hearing's being recorded audio only is my understanding. And we will try and get the links to the recordings up onto the Engage Victoria website as soon as we can after the end of each day's proceedings. Now, I've not used this venue before, so if you, like me, are a newbie in this venue, the toilets are out that way and around the corner. If in the unlikely event that there's an emergency, we're just going to sit here and wait for instructions from Clifton staff, because there is a emergency exit map, but I can't make head or tail of it. So I'm sure someone will come and assist us if we need it. I'm just going to go through a couple of protocols for those who are joining us online. So if you can just make sure that you keep your microphones muted and your cameras off unless you're going to be speaking. And if you need to raise something with the committee, if you use that raise your hand button on the Teams screen. Please don't use the chat because there's too much going on in a hearing for us to keep an eye on the chat, and things will get missed if they're in the chat. Use that raise your hand button instead. Now, we do have technical assistance from Ken, who's in the corner back here for those of us who are in the room. I'm going to give you Ken's number. So if you do have any technical issues during the course of the hearing, you can give Ken a call. His number is 0408 694 643. Okay, we've just got a little bit of introductory material to get through this morning before we start with opening submissions, and I'll start with introducing the committee. So my name's Sarah Carlisle and I'm the chair of this Inquiry and Advisory Committee. I've been a senior panel member with Planning Panels Victoria for around 7 years, and I was a sessional member for 3 years before that. My background and expertise is as a planning and environmental lawyer. I've worked both here and in the United Kingdom in both private practice and in government. I'm going to get my fellow members to introduce themselves. I'm going to start with the Deputy Chair, Member O'Neill.
Thank you. My background is a town planner. I've also got experience in regional economic development. I've been a sessional member, or senior sessional member now. I've worked with the organisation since the year 2000 and sat on a wide range of EES matters and also planning scheme amendment type work.
Okay. And Member Burgermeister?
My name's Kim Burgermeister. I'm a sessional member. This is my first rodeo, but I have been practicing mechanical engineer for the last 20 years, 25 years. Specialising in acoustics, and was previously a member of the Federal Government's Independent Scientific Committee on Wind Farms.
And we have Member Briscoe online today.
Yeah, my name's Sandra Briscoe. I've been a sessional member of PPV for 7 years. My background is in environmental science and management, and I've been working in that field as a consultant and in research for over 30 years.
Okay, now if you're wondering what to call us, you can call us Member Carlisle, Member O'Neill, etc. We're being assisted in this matter primarily by Amy Selvaraj, who's down the back there in the blue jacket, and also Sarah Vujinovic will be, I think, in and out, helping us out. So if you have any questions about the process, you can contact Amy. I think Amy in the first instance at the planning panels at transport.vic.gov.au email address. I'm going to ask the parties to introduce themselves and let us know who you're representing and your teams. And I'm going to start with the proponent, Mr. Townsend.
Good morning, and thank you, Member Carlisle and members of the committee. I represent Viva Energy Australia Proprietary Limited, which is the proponent, along with 3 other barristers who are all here today. Mr. Chessel to my left, Mr. Chale to his left, and Ms. Mann to my right. That is the same as the appearances as you've listed them in the timetable, but I can indicate while it's a full deck today, it'll actually be one or other of us. And in fact, Mr. Chessel and or I will sometimes have the carriage of the case, as it were.
Mm-hmm.
We're instructed by Davis Advisory. Ms. Gregg's here today with some of her staff, and there's a fair team here from Viva that I won't introduce today. And likewise, they'll come and go throughout the hearing.
Okay, thank you. I'm going to start with you, Ms. Chorn.
Thank you. Ms. Chorn, I appear on behalf of the Environment Protection Authority. I'm assisted by Ms. Chloe Hall, who's instructor from EPA Legal, and also Ms. Jennifer Martinez, who's seated behind me, is from the Major Projects Unit within EPA.
Okay, thank you and welcome. Mr. Finanzio?
Oh, I haven't got my microphone on, sorry.
Oh, there you
Should
go.
I start again? Okay. I appear for Geelong Grammar School, and I'm assisted by Ms. Collingwood, who is to my right, and Ms. Armstrong, who is not present today, and we're instructed by Mr. Tobin, who is here. And there are representatives of our client who are present, but I won't trouble you to introduce them.
Okay, thank you. Is anyone from the Impact Assessment Unit here today?
Hi, Chair. I'm Marco Gutierrez from the Impact Assessment Unit joining online today. Thank you.
Okay. Hi, Mr. Gutierrez. I think we're going to be joined by Dika later, who are also presenting an opening submission today. Ms. Clooning, are you online yet?
I am indeed. Member Carlisle, Jane Clooning, Team Leader Planning and Environment Assessment Energy, and I'm representing, as you've said, Department of Energy, Environment and Climate Action, DECA region.
Okay.
Thank you.
That's all our parties who are certainly going to be appearing today, so welcome to you all. Just a little bit about the proposal. So the project is a proposed liquid natural gas or LNG import terminal at Geelong. It's proposed to be located at Refinery Pier alongside the existing Geelong refinery. Viva Energy Gas Australia Proprietary Limited, or we're just going to call you Viva or proponent through the course of this process. They're the proponent for the project. They also operate the refinery. The key objective of the project is to facilitate a supply of gas for the Southeast Australian gas market to address a predicted shortfall in supply in Southeastern Australia in coming years. The project will use a floating gas terminal, which is a ship known as a floating storage and regasification unit, or an FSRU, that'll be moored permanently at Refinery Pier. The FSRU will receive LNG from incoming visiting LNG carriers. They'll store it, then regasify the LNG to meet residential, industrial and commercial customer demand. The proponent was required to prepare an EES for the project, which was exhibited in February to April 2022. That original EES went through an assessment process by an inquiry and advisory committee that consisted of Member O'Neill, myself and Member Brisger. So Member Burgermeister wasn't on the original committee. That was Member Wimbush, but he's no longer works for panels. He works for VCAT. Nothing bad happened. He just decided to take a different path. And so they, the original EES went through that assessment process. We provided our report to the Minister for Planning in October 2022. And then in March 2023, the Minister directed that a supplementary statement be prepared before she could complete her assessment of the project's environmental effects. And that supplementary EES was exhibited in September and October this year, in response to which we have received 389 submissions. We've been appointed as both an inquiry under the Environment Effects Act to assess the supplementary EES and the submissions on it, and also as an advisory committee under the Planning and Environment Act to assess the updates to the draft planning scheme amendment that is intended to provide the planning approval for the project and submissions on the planning scheme amendment. We are a joint inquiry and advisory committee, but I'll refer to us as the IAC or the committee. Our role and purpose is set out in terms of reference that were issued by the Minister for Planning on the 8th of September this year, and those terms of reference are available on the Engage Victoria website. Our terms of reference make it clear that our role is to assess what's called the relevant environmental effects of the project. The relevant environmental effects are those dealt with in the supplementary EES. They are impacts on the marine environment, noise impacts, impacts on air quality, and impacts on underwater cultural heritage. Clause 6 of our terms of reference make it clear that it's not our role to re-examine project effects beyond those 4 relevant environmental effects. So we won't be revisiting other matters that were dealt with as part of the original EES inquiry process. We do encourage all the parties to read and be familiar with the scope of matters that we must consider and the matters that we must report on when you're preparing your submissions and presentations to the IAC, to make sure that your submissions remain within the scope of what we have, what our task is to consider. Okay, now there's some guidance material that's been published that provides some information about what happens in an inquiry hearing such as this. We had a guide attached to our 29 October letter, which is the first letter that you will have received from us, letting you know that we'd been appointed. That guide sets out in detail what happens at a hearing. It explains the difference between an advocate, an expert, and a submitter, and what their roles are in the hearing. It explains who can ask questions and who can be asked questions in a hearing. And generally speaking, it's only expert witnesses who can be questioned or cross-examined by other parties, although other parties may have questions of clarification for one another, which they need to direct through me. There's also some information in that guide on how to prepare and present a submission for those who haven't done this before. Some of the key points to note about our hearings are that they are public, and as I mentioned earlier, this hearing is being recorded, audio only. Any material provided to the IAC will be a public document unless you're granted approval from the IAC to present that material confidentially. The hearing will be in person, but we've got video conferencing facilities, so people who aren't able to make it to the hearing in person can still participate by presenting online. We're expecting parties to present their material to the IAC electronically, and there are detailed instructions on how to screen share in that guide that I mentioned earlier that was attached to our letter from 29th of October. For those submitters who are attending the hearing in person, someone from PPV will be on hand to assist you with screen sharing if you need it, or we've got Ken who's providing tech support to our participants in person as well as our participants online. Parties need to circulate the material they're intending to present to the IAC by 12 noon the day before. Don't assume that the IAC will have read the material by the time you come and present it. That's just so we can get all the material we need downloaded and filed, and we know where to find it on our computers. Also, just a reminder for parties that any material that you want to present to the, any material that you want the IAC to consider has to be presented to us through this hearing process. It's very rare that we would accept material other than through the hearing process, and that's because we need to ensure the process is transparent and that all parties are aware of all of the material that's been put before the IAC and that we're considering, and they have an opportunity to respond to that material. Now, we have a quorum of at least 2 members that have to be present for us to conduct this hearing. One of them has to be either myself or the Deputy Chair, Member O'Neill. We won't all be sitting every day. We will be calling on our technical members, Member Burgermeister and Member Brisger, to be present when their areas of expertise are being discussed. But you'll have the pleasure of the company of myself and Member O'Neill for every day of the hearing, unless something unusual happens. Just a reminder about cross-examination. So any party can ask questions of the experts, but we just wanted to remind you all that Direction 27 of our directions requires the parties to let PPV and the other parties know by 12 noon the day before the relevant witness is scheduled to appear which experts you intend to question and how much time you anticipate you're going to need to put your questions to each witness. That just helps us to keep on top of the timetable. So We're expecting that information by 12 noon today for parties who have questions for Mr. Rawlings or Mr. Lane, who are going to be giving evidence tomorrow. And then we're expecting that information by 12 noon tomorrow for parties who have questions for Mr. Evans and Mr. Tardio, who will be presenting their evidence on Wednesday. Now, just a little bit about what's happened up to now. We had a directions hearing on the 12th of November. We set out procedural requirements for the conduct of the hearing and the exchange of information in the lead up to the hearing. Since the directions hearing, pursuant to the directions that we issued on the 14th of November, we've received some additional information, and I'm just going to go through the list of what we've got. We've got drafts of the hydrodynamic modelling report prepared by Hydronumerics. We had a working draft dated February 2024, and we've got an updated draft dated November 2024, along with technical note number 1 that explains the status of each draft. We've received the proponent's Part A submission, including a submission summary table outlining the proponent's initial response to submissions by theme. And we've got technical notes number 2 and 3 from the proponent that provide more detailed responses to the submissions from the EPA and from DECA. We've got Stantec's response to the IAC's questions about CEE's response to Stantec's peer review report dated the 5th of August 2024. We've got expert witness reports from the proponent. We have a report from Brett Lane on threatened and migratory birds, from Cosmos Coronios on underwater Aboriginal cultural heritage. That was received by us on a confidential basis. So I don't think that's been circulated to the parties. We've got a report from David Rawlings on air impacts, a report from Ian Wallace on marine ecology impacts, from Tom Evans on noise, and from Peter Yates on the hydrodynamic modelling. We've got expert witness reports from the schools experts. We have a report from Paul Gard on hydrodynamics, a report from Matt Edmonds on marine ecology impacts, and a report from Darren Tardio on noise. We've got joint expert statements in the following areas. So marine ecology impacts and noise. And we understand the parties are proposing a further joint expert meeting in hydrodynamic modelling, which I'll come back to in a second. We conducted a site visit last week on Wednesday that included an accompanied tour of the refinery pier, and parts of the Geelong Grammar campus. We also had an unaccompanied site visit that included the Lagoons Boat Club, the Hovels Creek Trail, and a representative sample of the air and noise monitoring locations that have been used to prepare the information needed for the supplementary EES. The site visit and itinerary and maps have been uploaded to the Google Drive. I think they're probably on the Engage Victoria website by now as well. So if you want to know exactly what we saw, have a look at document 54. We had originally proposed to visit noise and air monitoring locations on the Avalon College campus, but the school required all attendees to have current working with children checks before we got on the campus, and we just couldn't organise that in the timeframes available. So we haven't visited Avalon College, just so you know. We actually were curious as to why we would need working with children's checks, because we weren't going to be unaccompanied on the Avalon College campus. But if we do need, if any of the parties think we need to visit Avalon College, we've got until to sort that out. So we might just check in with you later on in the hearing as to whether you think that's necessary. In terms of document sharing, so the proponent has set up a Google Drive for the parties to share documents required for the hearing. There's 2 folders in the Google Drive. There's a documents to be tabled folder, and there's a tabled documents folder. Once the documents have been presented and tabled, they're going to be uploaded to the Engage Victoria website, and we try to do that, within a couple of hours after the conclusion of each hearing day. So if you're looking for documents that are going to be discussed the next day at the hearing, look in the documents to be tabled folder. And just a reminder again that any material that's going to be presented needs to be uploaded to that Google Drive documents to be tabled folder by 12 noon the day before it's presented. Now we've got a couple of procedural issues to deal with before we hear an overview and an opening submission from the proponent, and also opening submissions from the EPA, from DECA and from Geelong Grammar School. Now, firstly, I wanted to talk about the Marine Joint Expert Meetings. So when we initially directed a marine conclave, we understood that we would have 2 marine experts, Dr. Wallace and Dr. Edmonds. Those 2 experts have had a joint expert meeting, and we've received a statement from them last Thursday, which is document 59. Since we issued our directions, both the school and the proponent have indicated they're intending to call hydrodynamic modelling evidence. And we understand, well, we've got expert reports from both your experts. We understand that you're proposing to organise a further conclave. There's been some issues around Dr. Gard's health, I think, which has slowed that process down. We just want an update as to what's happening, who's invited, when it's intending to happen. I might go to you first, Mr. Townsend.
That's fine. Mr. Fernandez and I've been chatting about this morning. The situation is that his witness, Mr. Gard, is well.
Yes.
He's reached out for a conclave as soon as today. We understand it's not immediately convenient for our Mr. Yates. Not so sure about Dr. Wallace, but if they can't meet today, they have a time scheduled for tomorrow.
Yes.
The follow-up from that will be that let's assume they then circulate some notes. You might get it tomorrow. It might be the Wednesday. It is relevant to a second aspect, which is when they might be called to give evidence. We've also had a chat about, but I'll wait till you want to talk about the timetable to address you on that.
Great. So is the intent to invite Dr. Yates, Dr. Wallace and Dr. Gard? Are they all doctors?
I think they are, yeah. And but I think that is, yeah, it's agreed that Mr. Edmonds doesn't take any expertise or interest in the hydrodynamic
in the modelling. Okay. And you're okay with that, Mr. Fernandez?
Totally. A bit like last time, you'll remember that Dr. Wallace straddled hydrodynamics as well as marine ecology.
Yes.
So we expect Dr. Wallace to participate in the conclave as well.
Okay. And you're comfortable with Dr. Edmonds not participating in that conclave?
Totally comfortable.
Okay. All right. Okay, so that is a nice segue into timetabling and scheduling of evidence. So we had asked the school and the proponent to liaise with each other about what order they wanted to call the evidence in. When we issued the version 2 timetable last week, we hadn't quite got that locked down. So we just took a stab in the dark and thought noise first, marine second. And I think we've landed on a situate or an order at least that everybody's comfortable with. Now, the proponent sent some correspondence around last Friday that confirms that you guys agree that noise should go first, and we'll deal with noise in week 1 with marine evidence to follow in week 2. We want to make sure, if we possibly can, to get all the marine evidence heard this side of Christmas. We really want to avoid having to split the evidence.
We both agree about that.
Okay, excellent. We're all on the same page there. So in that regard, option B in your instructor's letter from last week was certainly our preferred option, which had all the evidence going first, and then we would hold over submissions until January.
Can I just, I think this is how it appeared in option B, but perhaps because I don't have it open in front of me, if I could just respond to that quickly because we've also been chatting about this morning.
Yep.
But yes, calling week 2 marine, we're hoping that the day 1 of that, the Monday, would be for the both witnesses on hydrodynamics,
Yes.
and that the marine ecology, or that Dr. Wallace and then Dr. Edmonds would commence. That'd be the Tuesday, Wednesday and into the Thursday if needed. And I can just explain that the reason is that Dr. Wallace for a long time has been very nervous about the second week of the hearing based on his other life as a wheat farmer with an impending very major harvest. And I've tried to negotiate a deal with him where if he gets the Friday and the Monday, he'll have a 4-day go at the harvest.
You're not going to go up there and
No, it
harvest
won't help
for
him. And he seeks selection. So I've told him and not before Tuesday, but we think that's fine because we can do the other witnesses on the Monday.
Okay.
And if that were the case, as you've just said, well, you might need in your timetable to then look at the knock-on effect for if you want submissions from us prior to the school, in which case you might, on return in January, be setting some side of time for us for those substantive submissions.
Okay. We wanted to float whether we might need to use our reserve day this Friday to get a start on marine evidence or get the cultural heritage evidence out of the way.
Well, can I just jump in and say you won't want to do it for the marine because we need that conclave to come back and for each side to get their instructions, and that might be Wednesday and it's a bit tight. But for the, if I can address you on the question within the bounds of what I can say on Aboriginal cultural heritage, it seemed to us that whether that's online or whether it's face-to-face, it's probably a brief submission from me, basically. We might just rely on the evidence that's been filed. Noting at this stage, it seems to be we're the only party addressing you. And I'd be happy to do that for you on Friday if that's suited, if that was a convenient time. Otherwise, it might be that there's a time to slot that in on a Thursday afternoon or the Monday. So I can be, given if it's just us and if you're hearing that on an in-camera basis, I can be quite flexible to your convenience on any of those days.
Okay.
If you're happy to do it that way, on that basis, I wouldn't be calling the witness. I'd probably just be describing the situation by way of submission.
Well, that kind of half works with what we were thinking. So we have some questions for Mr. Koronios. Okay. They're not extensive. Yep. We don't think we'll need him to present evidence in chief. We just think the most efficient way of dealing with that is to just get us either in the room or online so we can put those questions to him and hear your submissions.
Yes.
We've received some correspondence from the Wadawurrung that they're not intending to make submissions, but they would like to attend that closed session just to hear the discussion that happens. So we think we should schedule in. We'll probably only need, how long do you think you'll need for submissions?
Thought even if you've got a question to be the whole thing, I imagine would be less than an hour. I would have thought. But in the circumstances that the traditional owners would like to attend, you might prefer to do it face to face. I'm not sure, but we'll be in your hands as to that.
Yes.
But Mr. Koronios is not in Victoria, so if he's coming down, we just need a bit more notice for how to get him here, or we can Zoom him in.
Okay. Look, we could probably have Mr. Koronios, even if we did have a face-to-face session, he could participate online.
That's fine.
That seems to be the practical, like to come down to answer 10 minutes of questions for us. It's probably not cost efficient. So what we might do is park that for now, and Amy will be in touch with your people to organise when that session should happen, and that'll require some engaging with the Wadawurrung as well. So we'll come back to that.
Member Carlisle, I just didn't quite catch the flow of week 2 and the order of the witnesses. Could you just clearly state On Monday, we're hearing from, was it Wallace?
No, on Monday, you'll hear from Peter Yates, followed by Paul Gard, who the school's calling. Peter Yates, that the proponent's calling. And both are concerned with the hydrodynamic model, even though Dr. Wallace is part of the conclave, he can conveniently, I think, be questioned or address it as part of his evidence. So Monday would just be the two. The Tuesday, we'd imagine we call Dr. Wallace. And we think, I should have indicated, again, I think it's agreed that both Dr. Wallace and Dr. Edmonds would be very well served if they had more than 30 minutes to do their presentations.
We wanted to talk to you about that.
Okay. But coming back to that, nonetheless, we think they've both got a bit to get through. So we would have thought the Tuesday, Dr. Wallace, probably the Wednesday, Dr. Edmonds, and we're just unsure as to whether those two, that flows into the Thursday or not.
Are you both confident that we can get through all of the modelling evidence in one day?
Yes.
Have you thought about that?
Yes, we are. Based on a brief discussion I've had with Dr. Gard.
Okay.
I mean, they haven't had their conclave yet, but that's my expectation.
Okay. And then we sort of initially said 30 minutes. We like evidence in chief presented in 30 minutes. We're very conscious that the marine evidence is very technical in nature. The school, I think, indicated at one point that they thought maybe an hour and a half would be needed by Dr. Edmonds. We freaked out at that point, thought, oh my God. We came back with 45 minutes. We're getting some pushback on our constrained evidence in chief. Look, we're in your hands on that. I just want to kind of reiterate what we sort of said at the directions hearing, that generally speaking, if it takes longer than 45 minutes to an hour to get your key messages across, the key messages can get a bit lost in the detail. We will have read the evidence as you know. So if we can just ask, or if you can ask your experts to kind of.
We've heard you loud and clear.
Yeah.
And we've conveyed that to the witness. There is a lot of material, but we think we'll be able to do it a lot shorter than an hour and a half.
Okay. Because that really has some implications for whether we're going to get through the marine ecology evidence in those 4 days. We've got the Tuesday, Wednesday, Thursday, Friday. No, the 3 days, Tuesday, Wednesday, Thursday. Okay. All right.
3 days for 2 witnesses.
3 days for 2 witnesses. Okay, that's what we're working toward. All right, we'll see how we go. Now next thing on the agenda in terms of procedural matters is to talk about Dr. Wallace's supplementary statement. So Dr. Wallace prepared a supplementary statement responding to the Stantec material that's in document 32. At the same time we received the supplementary statement, we also received correspondence from the impact assessment unit. So Mr. Gutierrez, if you could just turn your camera on, because we'll be talking to you about this in a second. We had some correspondence from the impact assessment unit just raising some process concerns in relation to Stantec's involvement. That email has been tabled as document 44. I'm just going to provide a high-level summary of my understanding of impact assessment unit's concerns based on that correspondence. There were concerns about the proponent seeking to facilitate a meeting between Dr. Wallace and Stantec, and also concerns about the proponent contacting impact assessment unit directly in relation to whether Stantec had reviewed Dr. Wallace's expert witness report. So given that all of that was going on, we directed the proponent to remove Dr. Wallace's supplementary statement from the Google Drive until we'd had a chance to consider and work out what was going on. That raises 2 issues that we need to discuss this morning. One is the process around Stantec's involvement, and the other is whether or not the IAC should accept Dr. Wallace's supplementary statement. So I might deal with the process for dealing with Stantec first. just to be clear, the Impact Assessment Unit has extended Stantec's retainer to assist and answer questions from the committee, not from the parties or their experts. And Mr. Gutierrez, I'll just go through my understanding of where you're at, and you can correct me if I'm wrong. But any request for further information from Stantec must be put through us, through the committee. Parties are not permitted to contact Impact Assessment Unit or Stantec directly, except as provided for in Direction 19, which really allowed Stantec to get in touch with the authors of technical reports A and B directly if they needed further information to respond to those queries that the committee had put to Stantec dated 14th of November. As far as we're aware, Stantec did not need to contact the authors of those. I'm getting a shake confirmation from you, Mr. Gutierrez. So I can foreshadow at this stage that the IAC doesn't have any further questions for Stantec, although as we indicated at the directions hearing, it would be of assistance to the committee if Stantec were to remain available if required to address any further questions that might come up as the evidence is presented as the conclaves happen, consistent with clause 4 of the terms of reference. Mr. Gutierrez, have I captured the concerns that Impact Assessment Unit had in relation to process accurately? Is there anything else you wanted to say?
No, I think that's perfectly accurate. Yeah, any further questions for Stantec, we would be requesting those to come in writing from the IAC.
Okay. Mr. Townsend, did you want to speak to that?
Yes, well, there's two things. One is whether there's any correspondence between Stantec and our experts, but the second is whether you should receive Dr. Wallace's.
Yeah, I'm going to come to that.
Yeah.
Yep.
Well, as the second we say, it's absolutely you should.
Yes.
And I'd be surprised if there's any objection to that. So I'll assume you'd receive it, and it needs to be published so that those making submissions or others and other experts can see it. As to the first, the time's passed now for any correspondence between the two, but it was something I raised at the directions hearing squarely, that we thought given the nature of it as an iterative peer review, that we would seek that if they wanted to speak with us to get feedback or have any questions, that we would facilitate that. That's all that was.
Yep.
And in the end they haven't, and that's fine. There's some other, it's a bit irregular, the subsequent peer review, because it's a different author and it seems to do different things, but we can deal with that in our submission and in evidence. We don't need to have a conversation with Stantec about it. So our position is that's fine, but we do seek to have the Dr. Wallace's response received and given a number so that it can be part of the documents upon which you can rely.
Okay. Well, again, a perfect segue into the next item on the agenda. So we indicated in our letter of last week that our preliminary view was that we should accept Dr. Wallace's supplementary statement, but we wouldn't make a final determination on that until we had heard submissions from the parties. So is there anything further you wanted to say about that, Mr. Townsend, before I invite others? Okay. Is there any party objecting to the receipt of Dr. Wallace's supplementary statement? No?
I think we wrote saying we didn't anyway, but no.
Yes, I think you wrote saying we weren't intending to object, but we would have liked to have been asked, if I can paraphrase.
Maybe we said that.
So I am asking.
Yeah.
Yes.
No problem.
No objection. Okay. All right. Well, then we will accept that document. So we'll just ask the proponent, could you just please re-upload that to the Google Drive? We'll give that a number that can be part of the considerations by the various experts to the extent that they need to. Okay, next item on my agenda was in relation to the production of documents. So the school has been requesting some information from the proponent, and you, at our encouragement, have been dealing with that amongst yourselves. We just had a couple of letters from the school over the last couple of weeks indicating there might have been difficulties in getting the information that you needed. I just wanted to check in with you on
I
that.
think we've now got everything we've asked for.
Yes.
There might be some issues about that in the evidence, but there's no outstanding request.
Okay. All right, we've talked about our confidential session for cultural heritage. Mr. Townsend, are there any preliminary or procedural matters you wanted to raise? Mr. Finanzio?
No.
Ms. Chorn? No. Mr. O'Neill? Oh, yes. Look, we might just check in with DCAR. We're hearing from you this afternoon, but there was a question around whether you would need a further time slot next week to present another submission. So, Ms. Cluning, if you're still on the line, if you could just give some thought to that, we'll check in with you after you present your submission today as to whether you'll need any time next week. Any other parties wanting to raise any procedural matters or ask any questions before we get going? No one online? Okay, well, in that case, I'm going to hand over to Mr. Gutierrez, who's going to present us with an overview of the EES process. Now, we received a written document from you last Friday, Mr. Gutierrez, which we understand you're going to take us through today. So I'll hand over to you.
Thank you, Chair. Good morning, Chair and members of the Inquiry and Advisory Committee, IAC, and other parties of the hearing today. I would like to start by acknowledging the traditional owners of the land on which I am speaking today, the lands of the Wurundjeri people, as well as acknowledge the traditional owners of the various lands on which others are located today. I would like to pay my respects to elders past and present and to any First Peoples that are here today. My name is Marco Gutierrez Gonzalez, and I'm a Senior Impact Assessor in the Impact Assessment Unit within the Department of Transport and Planning, or DTP, State Planning Assessment and Facilitation Division. The State Planning and Assessment Facilitation Division is responsible for the administration of a range of planning and assessment functions under the Planning and Environment Act, which includes the Impact Assessment Unit. The Impact Assessment Unit, or IAU, is responsible for administering impact assessment on behalf of the Minister for Planning, particularly under the Environment Effects Act and the EPBC Act bilateral assessment agreement. DTP IAU administers assessment processes such as EES and environment report processes on behalf of the Minister for Planning. Along with Ashley Ekanayake and Brianna Mitchell, I have led the management of the supplementary EES process for the Viva Energy Gas Terminal project under the Environment Effects Act and in accordance with the ministerial guidelines and the minister's directions issued for the supplementary EES. I have prepared a written statement which has been supplied to the IAC and has been published on the Viva Energy Gas Terminal Project Supplementary EES IAC webpage. I do not propose to read the whole statement supplied, but I'd like to take this opportunity to highlight a few points. So this statement is made on behalf of DTP IAU for the purpose of providing context to the process. It is not made in relation to the merits of the project, the supplementary EES itself, or the predicted effects, or the substance or of the submissions made by any party. DTP IAU provides this information to keep background on the EES and the supplementary EES process and set out relevant matters for the IAC and submitters to understand the process undertaken to date. In due course, DTP IAU will be in receipt of the IAC report for the supplementary EES. DTP IAU will be responsible for advising on the Minister's assessment of the project's effects that will be issued under the Environment Effects Act at the conclusion of the EES process. The Minister's assessment will inform statutory decision-making on the project. In December 2020, a former Minister for Planning determined that an EES was required to assess the likely significant environmental effects of the Viva Energy Gas Terminal project under the Environment Effects Act 1978. The original EES was exhibited and then considered by the Viva Energy Gas Terminal Inquiry and Advisory Committee, the EES IAC, which submitted its report to the Minister on October 5, 2022. Having considered the EES IAC report in March 2023, the Minister determined that a supplementary EES was required to further assess the likely environmental effects of the proposed project on marine environment, noise, air quality, and underwater Aboriginal cultural heritage. These are the relevant environmental effects for the supplementary EES. The key stages of the supplementary EES process have been managed by DTP IAU consistent with the procedures and requirements in the Minister's directions and are as follows. A targeted agency-based technical reference group, or TRG, was established by DTP IAU to advise the proponent and DTP IAU. The TRG met on 8 occasions between August 2023 and July 2024 to discuss issues relevant to the Viva Energy gas terminal project, to review and advise on draft material prepared by the proponent for the supplementary EES. DTP IAU engaged an independent peer reviewer, Stantec, to review and provide advice on the scope and adequacy of the proponent's supplementary EES draft study program and on the technical adequacy of the supplementary EES assessments and documentation, specifically for marine environment, including hydrodynamic modeling and threatened migratory birds assessments. The independent peer reviewer's comments and the proponent's response to the review is provided in attachment 1 of the supplementary EES. The supplementary EES documents were finalized and exhibited for public comment from 12 September 2024 to 24 October 2024. By the time the final draft of the supplementary EES was submitted to DTP IAU for authorization to exhibit, there was some differences of opinion between specific agencies represented on the TRG and the proponent. The technical issues included matters related to assessments of marine environment, underwater Aboriginal cultural heritage values, and amenity, including noise and air quality. Agencies represented on the TRG have had the opportunity to raise outstanding issues in their submissions on the supplementary EES. So any outstanding issues stemming from their TRG engagement with the proponent during the development of the supplementary EES will be matters the IAC will be able to examine via these submissions and, if necessary, further through the hearing. At the completion of the public hearing process, the IAC will prepare a report on the findings and on the significance of effects and recommendations of any necessary mitigation controls and/or project refinements as per the IAC terms of reference. The final stage of the EES process will then be for the Minister for Planning to issue the Minister's assessment on the effects of the project to inform statutory decision-making for the project. The Minister's assessment must be considered by Victorian statutory decision-makers. It will be very helpful to DTP IAU in terms of advising the Minister about her assessment if the IAC provides in its report recommendations for any appropriate conditions that may be lawfully imposed on any approval for the project. Thank you, Chair. That's my statement. We can hear you online. I'm sorry.
Sorry, I had my microphone switched off. Apologies
Thank you.
for that.
All good.
I was just checking in how I should be addressing you. Is it Mr. Gutierrez or Mr. Gutierrez Gonzalez?
Mr. Gutierrez is fine. Thank you.
Thank you for that submission. I'm just going to check in with my members as to whether anyone has any questions. Thank you. Thanks for coming along.
Thank you.
Okay, next up we have the proponent. Now we're going to be receiving an overview of the project as well as an opening submission and an overview of the supplementary EES. Which document should we have open first, Mr. Townsend?
Thank you, Member Carlisle. The documents that I'll be going to this morning, document 23 you need handy, which is the Part A submission. I won't be reading it, but I might show you things.
Mm-hmm.
The opening submission, or otherwise known as our Part B submission, is document 65.
Mm-hmm.
I'm going to, that document again, I'm talking around rather than reading from, but there are some pages I'll actually read. Then there's, we have a presentation that I'm going to talk to of just some slides for the purposes you've described, which is document 66. There are other documents. Document 48 is the day one version of the mitigation measures. I wasn't going to spend much time on those, just refer to them in passing for reasons I'll explain. And I might, with Ms. Mann's help, be just screen sharing some pages from the IAC's report and the Marine and Coastal Act, but we can just do that on screen sharing if that's okay.
Yep, sure.
Right. So, oh, not just yet. We'll go to the presentation in a moment, but may I commence on that basis?
Yes.
Thanks very much.
Thank you.
Well, no, thank you again, Member Carlisle and the committee. With those documents just available to you, can I indicate that the way I hope to use the next hour and a half or so is really going to move between those documents and in particular talk to some slides. And I'll be clear to indicate for you when I am going to a document, but otherwise I might just be addressing you with some oral submissions, in which case can I indicate, I know it's been recorded, but we'll also make sure to collect those propositions for you in our written submissions that come later, so you don't have to go making too many notes. The next thing I thought I should say at the beginning is the reason I won't go to the mitigation measures, and I'll show you by reference to the submission, is that it seems to us that while you have the day one version, particularly having read the EPA submission, that there are a couple under air and also for some of the monitoring work for the operations in the marine ecology sense that we'll do some further responses to that. So there's one way or another, at the very least, going to be a day two version. But we will, when we see the other submissions coming forward, be identifying that and trying to assist behind the scenes, as it were, if we can do drafting that the agencies are seeking to try and resolve those issues in parallel with the hearing. So I wasn't going to spend time on the detail of those this morning, but what I was going to do is suggest that as we get to each topic, we might then take you to the relevant mitigation measures and explain for you where we understand there's an outstanding issue or it has been closed off or not. But the other documents I said I'd take you to this morning include the committee's report. And I just wanted to start before I go to the documents by acknowledging that I wasn't here on the last occasion and nor was Mr. Chessel. And experience actually suggests that can be an advantage. Coming to a hearing when you think something happened at a hearing, as opposed to with fresh air, is sometimes beneficial. But I'm also cognizant that not having been here might mean I say things or spend time on things that are particularly well known to at least three of you, and you can let me know. But it does seem to us in the main propositions we want to advance this morning that from arriving at the hearing, there are a couple of themes around which I'll be focusing on this morning that may or may not be evident from the way the report's written on the first occasion, and I don't mean to suggest anything's right or wrong. There's a whole series of topics dealt with. But there are two in particular that I'll be focusing on this morning. One is the role of this committee as it concerns existing conditions and the current operation of the refinery as part of the existing environment, not as a separate impact to the environment. And that's probably clear on the last occasion, but at the risk of re-emphasising that, it's certainly a theme I want to focus on this morning. Mm-hmm. And the second is, having read the committee report, a sort of what I suggest is a curious distinction between tools used to assess the environment by reference to a descriptor being an ecosystem-wide based approach or some other approach, and even a reference to the Marine and Coastal Act in that regard, And I'd like to focus on that for reasons that are more conventional. I'd suggest for environmental effects assessments that all assessments very much turn on the particular facts and circumstances, and that affects adequacy of information, conclusions, readiness to be able to form judgments around acceptability and the like. And it just seemed potentially jarring that there was some suggestion that the tool might be somehow a creature in its own right, as opposed to the outcome that we're trying to achieve through a process like this with all available information. So just introducing it that way, I just flagged that because they are the two themes that I'll be mainly focusing on, notwithstanding the other submissions we've presented and the other broader matters I need to cover for you this morning. So if I can just now turn to document 65, which is the second, if you like, or the opening submission. I just want to show it to you so that I can explain why I'm not reading it out to you. And I'd like to start at the back of the document. So because at the very back of the document, you'll see at pages in hard copy 33 and back to 31 that we've dealt with each of the topics that you'll be hearing from us through the evidence. And I can indicate that when we first drafted this document, we thought the evidence was running in a different order, and hence there's a fair bit of detail in this document around marine matters, not the noise matters. But what I thought that we'd do is just indicate for you that obviously under Aboriginal cultural heritage, we've simply made reference to that on the basis that we'll make a separate submission to you about it. And we've indicated on noise that you'll be getting a separate standalone submission. So that'll be Wednesday morning. Mr. Chessel will take you to that. And so far as we've addressed threatened and migratory birds, I'll touch on them in the slides, and likewise with air. But we think that we can conveniently take you further into those matters at the time we call the witnesses on those, rather than take you in detail through every topic this morning. But because we've put a bit of time into marine in this document, and because it is seems to take on a central role in terms of the evidence, I will spend a bit of time on that aspect in these submissions this morning. So staying on that document though, the first part of the opening submission today, and indeed a fair bit of what we've set out in the Part A submissions, does simply acknowledge that the committee this time around has quite a specific and confined role, and hopefully for you that's some relief as against the first occasion where there were so many topics that you had to deal with in the context of writing your report. And what we've set out for you in the Part B submissions through the introductory parts and through those sort of early pages up to about page 10 is really just setting the scene for you on the Act and what the courts have said that might assist you in understanding the role under the Environmental Effects Act. And in this case, dealing with additional information, which is a requirement and a statutory invitation under the Environmental Effects Act, not under any other act, and therefore those directions that very much direct you to those particular topics. Although within the nonetheless of the Minister seeking advice from you around the question of acceptability and also adequacy in terms of information. And so in terms of both of those propositions, we will touch on the notion of acceptability as relevant to a project like this, and also adequacy as relevant to both a project like this, but also the expectations within legislation about how much you need to determine whether you have enough information to give advice, regardless of the many number of ways someone might choose to prepare information. And we see that as really a fault line, ultimately, in the differences that we don't have with the agencies, but we appear to have with the school and its witness about just the sheer volume and detail of information that it claims is required for you to be able to make an assessment in these circumstances, and which will ultimately submit is just, while not necessarily, while potentially laudable, is way beyond what's necessary for you to discharge your functions for this EES, and indeed for many, we'd say. So, so really those early pages designed to invite the revisitation of your inquiry, whether it's by reference to marine ecology, noise or air, to be very cognizant of the particular facts and circumstances that you're dealing with in Corio Bay and at the refinery as critical matters of evidence of the existing environment, not as separate from the existing environment at Corio Bay. And so as a result, we say at our paragraph 20 in the Part B submission that given the particular circumstances of this project and its integration with processes undertaken at the refinery, many of the effects of the project are able to be understood by reference to existing conditions. And we would say the existing environment, and the capacity to integrate water discharge from the regasification unit with the water cooling system that is presently operating is an example of this. And it's so fundamental that when I'd submit to you in coming and reading and reviewing this project, it is such a stark difference between it and the Crib Point one that I'd previously been involved with, that it makes it a fundamental differentiation of this project from certainly the only other one that's been assessed in Victoria. And it's so important in our submission that that be thoroughly understood, that you'll hear me revisiting that in the slides to come. The other point we've made in those early paragraphs before I go to the presentation of slides is that in the revisiting the four issues, you are nonetheless still distinguishing between the source and nature of the impact of the project, and generally there's construction and operation, and it seemed to us that much has fallen away in the context of the construction phase, and we understand with the EPA we need to revisit mitigation measures in the marine sense further for operation, which we can do. But it's something I'd also like to address you on as we come to the slides. But you'll hear the focus from us is more around operation by reason of what we say is the additional work that's been carried out. So what I'll do now, if it's all right, is I'll ask Ms. Mann just to share these slides that I'm going to walk through, some of which we'll jump over pretty quickly, and most of which addresses matters that are perhaps useful by way of refresher for three of the members, but are probably well known to the members from your inspections and the reading of the materials. But if are they on screen yet? Yep, thank you very much. So we'll move straight on to the first slide, which is simply a location overview. These won't be new matters to you, but it does provide a site that indicates on it at that resolution and at that zoom out of the proposal showing a dredged area being the yellow, the green being the, if you like, above surface works, including pipelines, through to the red, which is the underground connection for transmission. I'm sorry, I thought I was on. Can you get this image up? Oh, is it? Didn't make it. Oh, there you go. I'm talking to an image you haven't got. I'll have to do better. If we go to that image, this won't, I'll try and cheat with what I've got, but you haven't got. That's just an EMAP resolution. And in fact, it doesn't even go as far as the area that I had on my image. What I wanted to explain, and perhaps you can indicate for me, Member Carlisle, can I assume you're aware of the existing deposit for spoil for dredging off Point Wilson in the back? Good.
Generally, I mean, if you ask me.
No, there's a slide that does it better than that. That's fine.
Yeah.
So, yeah, well, we'll come to that. Can we come back to the order? The near map image that's just an image for you to have at hand, which is a better resolution aerial image, but which I don't intend to focus on based on your knowledge of the project. And I do have some aspects of that I'll come back to. But the next image, if we can put the next slide up, goes to gas outlook. And I was going to deal with this later, but I might just knock it over in one go if that's all right. The reason for introducing a slide on this is not because you're asked to revisit this issue in your directions. It's not before you as such, but we thought it was appropriate for you at the very least to be updated on the basis of this slide showing that so far as the market operator is concerned in 2024, you'll see that nothing's changed in terms of the development or committed supply of gas for Southeast Australia. So in one slide, it's really just to reinforce, if not the status quo, potentially a continuance of that predicted shortfall. The reason I said I'll address some other matters on this at the moment is that there's been a comment made in one of the opening submissions that you should be aware of some speculated project elsewhere in the bay for potential gas delivery services. And I'll say a couple of things about that. But the first is that in the Part A submission, we have addressed this issue at page 10 and 11. There's no reason to go to it. We have set out at paragraph 22 of the Part A submission the findings the IAC made on the last occasion, and we say those findings remain accurate. And we have made a comment at paragraph 25, which aligns with the slide that we've got on screen to the effect that there's been no change and there remains predicted shortfalls. The real point I'd like to take you to is what's the committee meant to do with that information? And in our submission, it really is not so much a question of need as a question of project rationale. And the ministerial guidelines for the assessment of environment effects statements requires that an EES sets out the project rationale. Sometimes that project rationale in EESs gets taken to a fair level of scrutiny or to demonstration of need for other purposes, or often in conjunction with assessments under the Planning Environment Act. But we say it's as simple as this, that when assessing an environment effects statement, or indeed a supplementary one, committees are asked to be turning their mind to acceptability, which always includes a component of tolerability, or the rationale, why would we accept any impact to the environment? And so the real point here is that the committee ought to be satisfied, and indeed the ultimate decision maker, that what you're dealing with here is the provision of energy, and that puts it at a particular level. Once a project is concerned with essential services or delivering warmth to households or energy for industry, it obviously takes on a particular emphasis that is legitimately incorporated when one is making a judgment about the acceptability of an impact. And to make up a comparison on the run, a wholesale removal of native vegetation even for pasture or for a racetrack would not have the same immediate impact or emphasis in the context of understanding how the project rationale might need to be borne in mind, at least in the subconscious, when exploring mitigation measures or acceptability. So the real point here in our submission is that this is a project that deals with a fundamental matter of energy. There's a clear policy and other emphasis and practical emphasis in why that's important. The next thing to say is on the question of alternatives, because the anticipated submission on this is you should look at alternative projects. And of course, the ministerial assessment guidelines for EESs specifically say it is not the role of an EES to look at alternatives to a project. That is expressly excluded from the guidelines as a task, let alone not a task of this process and not a task of your directions nor your terms of reference. So it would be an irrelevancy in our submission to be interested that somebody else might one day have some other proposal. But there's a more sinister, a more problematic reason with looking at alternative proposals, and it's really what I'd call a game of pass the parcel. And it's very important that decision makers and advisory committees address the evidence on the table in the context of the proposal they have before them. If a proposal is supported by a logic that it can supply any energy, that is sufficient for you to make that assessment. It is not an appropriate exercise to discount that logic or that rationale by speculating that that could be done some other way or somewhere else. That is actually a disenfranchisement from the task, and it is definitely not appropriate for Victorians more generally than even this project admits to play past the parcel when you're making a decision. You know, maybe someone else can do that another day. That's the antithesis of good advice or good decision making. So I thought we should pull that out now because it's not before you, but it is apparently to be alleged that you should have regard to speculative proposals or other projects as somehow assisting you in considering the acceptability of this project, and we say that's not correct and you shouldn't do it. So the next slide, having dealt with that issue, is just to go back to the facts, and all that slide does is provide you with some historical photos, furthest left appearing to be sort of from the north, an aeroplane in the 50s looking towards Geelong. Likewise, effectively from the east looking towards Corio Bay, and in the 90s the establishment further and operation of the refinery with visiting tankers in situ back then. It really, the slide goes probably no more than to demonstrate that it is important in our submission as a part of the available evidence and material before you to be acknowledged, acknowledging both the entrenched and continuing operation of the port, and in this case the refinery and industry in this location. It is not a recent facility, and it's can be assumed to be there for some time to come. It's also the case in our submission that the expectation would be, I think can be safely, that it's improved over time in terms of its impacts. But as you know, certainly over that period of life, it has been had attached to it further and other approvals and including and regulations that wouldn't have applied in the early part but apply these days. The next slide, staying on moving to a current operation, is simply a photograph again of some crude oil tankers in place, but a very general summary of the activity from the port side or the pier side of the refinery. The broad summary describes a crude ship every 3 to 5 days. We understand the crude ships have about a 2-day turnaround. They, if you like, they're the main feeder of the unrefined oil that is delivered to the refinery. There's a barge every 3 to 4 days. The barges really work as floating delivery fuel services to ships in the bay or the ferries and other ships that effectively collect and are delivered to from this facility. There's a product vessel every 4 to 6 days that is that includes finished product that's taken in and out of the facility on particular vessels. The chemical tanker once a month deals with a finished product of some chemicals that are sold or transferred from the facility. The fuel oil import of 1 per month is separate from the crude ships. It's a partly refined oil that is brought in that meets a different part of the market in its mixing, and the black oil exports are really the post-refined from the cracker unit oils that are the heaviest that are actually exported from the facilities. They go overseas or to other markets where they're blended for other purposes. But that's just a very broad summary of, if you like, the ship activity at the port, and it indicates over many, many years that's been the case, that ships are coming to and fro from the pier and unloading and loading as they will. The next slide is just simply another aerial view. You'll be very familiar with it. In the foreground, in that triangular area, roughly, you'll get is part of the treatment plant for the proposed gas, but otherwise that's just for your another image for your benefit. Likewise, the next one, having been on your site inspection, which is our next slide, it's really there as a reckoner for you. It identifies some of the existing activities around the site that you would have seen on your site inspection. Indeed, the next slide is your site visit map, just so that we thought if they're of assistance to you through the hearing or you're checking anything up, you can see the two side by side. But I assume I don't need to describe again the site inspection you went on. So then the next slide moves to the project, and it's a fairly simple description of what's proposed, and in some respects for the environment effects in our submission it is a simple proposal. And in that image shown in the computer rendering, you'll see the extension to the pier, effectively northwards and east, large enough to accommodate both the continuing placement of the floating storage and regasification unit and enough room for a delivery LNG carrier to dock adjacent to it for delivery purposes and to come and go. The image shows crude oil tankers still in place for the other function of the pier. And importantly, in the yellow dashed line, shows the seawater intake, if you like, to the refinery from the intake through the floating storage and regasification unit, which would displace, if you like, some of the existing intake. And I think you were shown the intake on your view for where that water is currently brought in near to the shore for the cooling purposes of the refinery. And that becomes a very important proposition. In fact, in our submission, critically important proposition, because it starts to show the integration and the synergies of what's proposed and the lack of change in an environmental impact sense with what happens now. The blue line is, of course, the surface piping as the gas within the floating storage and regasification unit, or as the liquid evaporates with the water that's flowing through the pipe in the system and the heat exchange that occurs. The pressure is such that the gas enters that blue piping. It runs around the refinery to the treatment facility where it's odorized before being connected to the transmission on its way into Melbourne and to industry on its way via the underground pipes started to be shown there by the dashed lines. The next slide is the one that Ms. Mann thought I was should have been talking to earlier.
Before you go on,
Yep.
Mr. Townsend,
Yep.
just a question, and I don't want to be pedantic here, but comparing that, and I understand that this is a artist impression sort of document, but comparing that image and the location of the ships and the extension of the wharf infrastructure is quite different to what's contained on PDF page in chapter 1 of the EES in figure 1.1. So just to confirm which one we should be referencing, the changes that I'm referring to are the location of the ships in the image that's on the screen are closer to the shore here. The arm is offset from the arm that goes off to the existing wharf. And I'm just wondering whether we should be, not that much turns on it,
Yeah.
but are we talking, are the ships going to be closer to the shore, or are they going to be more reflective of figure 1.1?
There are actually dimensions, I think we come to in a subsequent slide, that you should prefer, and you should prefer the diagram in the EES. You're right to observe that what we've got on screen is really of a more cartoonish nature to tell the story. So I'll end up answering you by saying rely on the documents that are, if there are any that are scalable, over what I've got here. What I'll do though, Member O'Neill, is do better than that with a little bit of hindsight later on. It's sufficient to say, I think, as you said, not much turns on it, but that this slide should be seen as indicative for the descriptive purpose of what's going on, not as an accurate representation of the final layout or design.
Thank you.
And
Just
sorry.
mindful of the time.
Yeah. How are we going? I was going to give myself a note for 11:30. How are we going? Past. Yeah.
So it's 25 past. Just you tell us when is a good spot to pause.
I was going to knock on your door at 11:30. So give me the 4 minutes, and is that okay?
Yep.
Because I can whip through a couple of the next ones. The next slide, if you just put up on screen, is the one I asked you about earlier. But that just provides some more information about, particularly the bay environs, but it includes showing you the proposed dredge disposal ground. You see that over off Point Wilson, and that is an existing dredge material ground within which there is a proposed area for the disposal of that which would be dredged for this project.
I'm just on the version that we've got. I don't think this image is in there. Oh, it's number 2. Yes.
Oh, sorry.
Okay.
See, I jumped around in my order. That's what I've done to you.
No, we've got you.
So you'll see that there. You've got the shipping channels are shown in that. You'll be aware, and I no doubt you were from the previous occasion, that you get dredging in association with the port and maintenance dredging of the shipping channels from time to time, and more broadly within the bay, obviously. And there is, I don't think it's the only existing dredge material ground in the bay, but it's one of them. There off Point Wilson. I won't, can you flick me through to, yeah, okay. There's nothing material to add there. That just shows you again, a high level description. The layout image is, again, it won't answer your questions as such, Member O'Neill, but is a closer depiction of the pier works and the mooring dolphins, which are of course embedded into the seabed and shown and depicted for the purposes of that slide. And finally, again, in a computer indicative presentation, the next slide, really a different angle, but I don't think adding materially to what I've described by reference to the other slides. And to bring you back to the process, and it was really at that point and the next slides that I was suggesting I'd pull up and come back to you with the process overview slide, and then moving to the those that go more to the existing operation. So if it was all right with you, that would be a good time for a cup of tea.
All right. We'll resume at 11:45.
Thank you.
Okay, Mr. Townsend, we're ready when you are. And also, I'm a bit hot. If anyone feels the need to take their jacket off, they should feel free to do so. Yeah. We've just got a question for you before you come back in, Mr. Townsend.
If I just go back and look at the figure in the cartoon, as you called it, where's it going on? I can't find it now.
Slide 10, was it?
I thought it was slide 10, yeah.
Page 10.
Yeah, slide 10.
Yes.
It shows the grey area, the treatment facility in the old gardens for the facility. It looks very large there. I assume the treatment facility is actually much smaller. There's a gantry there as well. Is that right?
the response I'm getting is yes, but I'm not able to take you to a diagram or a plan to
Right.
answer it better than that. But it's similar to a question I was about to answer for Member O'Neill, that I understand there are engineering drawings of these. They're not in this package because they're part of works applications or whatever, but we can get you better drawings if you're assisted both for the pier and for that facility.
I would just like to know the approximate size of that
Of course.
equipment. I mean, from the site visit, the treatment plant for the incoming water supply, seawater supply, was actually very small.
Yes.
So, and I know there's a gantry there to drop off some of the materials that you use for treating.
Yep.
I'd just be interested in seeing layout of that area.
Yes, certainly. Member Burgermeister, shall I go back then to the slide, which was slide 14? This is, again, a broad overview describing from the left to the right of that slide the floating storage regasification unit with the berthing, as I think you're understanding. The refinery pier extension is described here as an extension of 570 metres. The treatment facility is a reference to the building or the facility you were just asking me about, and describes here really its function to add the odorant to give it a distinctive smell before entering the pipeline on its way to the network. The next slide is really probably more complicated than I need for my purposes today, but it's really focusing attention on the proposal, which is heavily attached to the integration with the refinery operation. And I'll be showing you through slides, as no doubt you've heard before, just how integrated those processes are in terms of volume and existing conditions, with considerations required both as to chlorine but also to ambient temperature. But the bottom line is that in the proposal, with the water being the intake being through the FSRU before the refinery and coming out, it means that cooled water is entering to the refinery, and so it comes out at a less elevated temperature than existing conditions, which I'll show you in the next slides. So this is an important slide, the next slide. It's an existing conditions slide, if you like, but it is describing the constants that form part of the existing environment because of the existing facility. And there are a few aspects of this that are worth singling out at the risk of repetition from previous occasions. But the first is the reference. If you look at the blue arrow inbound from the water, it says 350 megalitres a day water intake. That is a pretty constant figure in terms of the intake of water from the bay now associated with the cooling purposes for the refinery, and it remains the figure in the proposal. The 5 other arrows describe outlets or discharge points, and you'll see that W2 is no longer in use, but it was historically a point. And W3, which has a small outlet there, is concerned with immediate discharge of like seaweed and like a backwash. So that's just really a bypass. It's a relatively small amount by comparison that's concerned just with the immediate clean out. So the key ones are W1, 4 and 5.
Just on that W3, the backwash, has that been chlorine treated yet?
No, I understand. That's before the process.
Yeah.
So W1, 4 and 5 each have a yellow circumference, which really is, in the old-fashioned language, the mixing zone, if you like. Under the licence, the area defined within which the mixing or impacts are meant to have been addressed. And you'll see that for W1, that's a 500 metre radius, for W4, 80, and for W5, 120. And they each have described the amount of discharge per day through each of those outlets, the largest being W1, which works as 228 megalitres a day. The other colourings on this that are important based on the existing operation are the dark green and the light green. But the dark green, you'll read, if you can read it in your version, is 10 micrograms a litre. That's a reference to the chlorine content. And you'll see that in each case, the dark green read at the 10 micrograms a litre, which is derived from a design guideline value that reflects obligations around ambience, if you like, that's achieved well within the conventional mixing zones and quite close to the outlet. The lighter green is added for these purposes. The 4.3 micrograms a litre was derived again from the design guideline value as it would apply if that were within a Ramsar site. But as you can see on the existing conditions, those envelopes, even at the 4.3, are some hundreds of metres from the Ramsar site. And that's the existing chlorine value for the existing seawater intake and discharge. And if we can just move to the next slide, it doesn't really assist visually particularly much, but the point is that in the proposal, there is no change to the chlorine plumes for obvious reasons, that the volumes and the discharge are as they are for the existing refinery. So the difference, if we go back to the previous slide, the practical difference with the 350 megalitres a day is not the volume, it's the split of that volume between the existing intake and what is otherwise now taken further out from shore through the FSRU unit. And when in the middle of winter, when the FSRU is at its peak operation, you might have about 300 megalitres coming through the ship and still 50 through the intake. And in summer, it might be more like 250 to 100 or 200 to 150. There'll be a split. But there is no change. There is an absolute hand-in-glove synergy otherwise with the operation of the refinery and the intake of that 350 megalitres a day, and the chlorination is the same. So the next series, the next
just
slide.
Before you move on there, I can see Dr. Brisker's got her hand up. So I think she's got a question for you.
Hello,
Yeah.
Dr. Brisker.
That's right, Mr. Townsend. Just a question about W3, which you said is a backwash area, but it's got a 100-metre mixing zone on it. I'm a little bit puzzled about that.
You hear me?
Sorry?
Oh, okay. Just hold fire, Sandra. We're getting a try that.
Can you hear me now?
Yes, perfect.
That's good. Sorry, Mr. Townsend. My question was about the W3 outlet,
Yes.
which you say is just a backwash area and it's showing 2 megalitres a day, but it's got a 100-metre mixing zone.
Yes.
So I just wanted to clarify what the purpose of that is, given that it's, if you're saying it's not chlorinated or got other contaminants, what the purpose of mixing zone is.
It's a good question. I'm sorry I won't answer it immediately, but I will answer it.
Thank you.
And while we've got that slide, the next slide is figure 12.1. What's the source of that slide?
These are Dr. Wallace's slides.
Yeah.
And he'll be coming back to them in his evidence. I've
Okay.
just pinched some stuff for the opening.
Thought I saw it somewhere. I was just trying to figure out where.
All right, and likewise, also from Dr. Wallace's material is the next slide, because we're moving to temperature now. Those ones were concerned to show you the existing environment with the impact of the refinery, those mixing zones and chlorine. The next slide really goes to the additional information list, and it shows you from a temperature point of view the 6 days of the further temperature readings at the different times of year, with some 1,000 or so measures per day on each occasion. And for each date, the temperatures at the discharge points describe the warmest by the red being the +5 temperature elevation. And from those 6 drawings or 6 collections of measurements, the highest on each day was used to then create a sort of a composite envelope. So not a real envelope, but a composite through the year. And so the next slide is showing you in a composite sense the existing temperature plumes by reference to an envelope describing elevated temperatures existing coming out of the refinery at the +5 closest to the discharge point, at a +3 and at +2. And you'll see even at +2 under existing, the elevation is somewhat removed from the designation of the Ramsar site. And again, for the purposes of assessment and performance, there is a design guideline value for Corio Bay, and for the obligation, as I understand it, to meet requirements for Corio Bay 3 degrees Celsius above is the design guideline value. So this is existing, and again you'll see that concentration around each of the outfalls, although you'll see not at W3, where the water has passed through the refinery process and emerged warmer as a consequence of having been through the cooling process. Significantly, if we go to the next slide, the consequence of refrigerated water having been through the floating storage regasification unit and then traversing around the refinery in what is, I think, less than an hour from water entering and leaving, is a reduction in the elevated temperature envelopes because the water was cooler before it entered into the refinery. And so the impact on the existing environment of the project, and of course, depending on the split of what's taken in through the existing outlet and what comes through the unit, will result in a reduction in the envelope or area that is affected by elevated temperatures. And so chlorine's the same.
Just on temperature. So in winter, when we can expect the FSRU to be at sort of peak production levels, so you're getting more refrigerated water going through the refinery and then coming out.
Yep.
Would you ever end up with a situation where you're effectively discharging water that's cooler than ambient?
No, it brings it down. It brings the elevation of temperatures down in the order of sort of, it's around sort of the 3 to 5 degree mark.
Yeah.
At all times, but never, it's always still elevated.
Yeah.
When it returns to the bay.
Yeah.
So the reason we're dwelling on this morning and hopefully assisting the committee is that, and why it's so integral to our submissions to you about how you need to assess impacts here, is that an impact or an effect is a change to the environment. And it's our submission to you that in your evidence of what the environment is includes these existing conditions. It's not an impact, it's not a separate impact, it's a description of the environment within which the effect is to be measured. And it means that there is no effect relative to the existing environment for chlorine, And it means there is probably some benefit or reduction, should it be seen that way, of the effect of the envelope that would be elevated above temperature in the bay. And so it's critical to our argument, you'll hear through the case, that be the basis of the environment that is being changed, not some artificial or speculative basis, or assume the refinery is not there, or trying to work out what the impacts of the existing refinery are. And we understood in the IAC's report its interest in the existing conditions to get more clarity around that, as opposed to trying to, if you like, separate out the refinery from the environment, which in our submission wouldn't be an appropriate analysis of the existing conditions or the existing environment that's being changed. So hopefully in doing this, there's other work I'll read you through, but hopefully the additional information or the extent this work's done, it's assisting in providing that clarity around the degree to which there's in fact any change or any material change, provided it operates this way. But there can be measures around that. There can be operational requirements around that.
But if that's the case, so put dredging to one side, because there's some sediment turbidity issues associated with dredging. But from an operational perspective, if what you say is true, then why would the minister have required an EES if all you're doing is reducing the impact on the existing environment of an existing facility?
Well, the person why the minister required it, not a question that have to answer, but it's not. This isn't the only impact. So I'm focusing here on chlorine and temperature, and of course the minister in requiring any EES is likely or potential.
Mm-hmm.
It's not a conclusion. So I think rather than answer it that way, I think the better answer is to say that it's your role in advising the minister to describe the existing environment. And we're submitting to you that includes, not excludes, those operations that are entrenched and happening and occurring on a day-to-day basis. So I can't answer for the minister, but there is dredging. There are other aspects of the proposal beyond these two. But the more important thing is that in light of the potential for environmental likely effects, we provide advice to the minister of measuring what that change is.
Yeah.
And if it turns out that it's negligible, that's always a consequence of environmental effects assessment. Where a minister has said, please investigate this. It's often the answer that it's negligible. So it doesn't matter what the presumption was when the EES was put.
Okay.
So, but it really is a fundamental deliberation, it seems to us. But not a question of, as I think we pointed out last time, we're not here to, if you like, review the operation of the refinery, but what we do need is put clarity around what those day-to-day implications are and how the proposal fits within those implications, not some artificial or environmental construct of the environment doesn't those day-to-day operations. So I'd like to move on. I've got limited time. I think it was important to stress that, but obviously it's part of the way the evidence emerges beyond here. But I thought I should show you the next slide, then just the seagrass mapping. It's described in the materials, and to save some time, I'll just say that the seagrass study included further camera work, and we've got Redmond says cameras aren't effective or whatever, but this is an extensive amount of work, and it describes also the changes in species of seagrass, basically following contours. The green's basically around the 6 metre mark and beyond 6 metres. You can see in aerial photos that no seagrass, where the dredging is no seagrass. Those species do change in dominance from the shallower through the deeper There's obviously a mix all the way through, that there's a dominance. And I should indicate, by the way, if you're looking at the names of those species, particularly the Nigrocaulus and Halifilla, I think they were once called Tasmanus. And you've probably seen in the publications with different descriptions. And I asked that Dr. Wells if they've changed the names for these in different publications, but we're talking about some.
Okay.
The depiction of that map, of course, has to be understood in the context that seagrass is not rooted like a tree, and it shifts and moves and migrates and transposes around the bay. And in these images, as I understand it, the conclusion is that of those coloured areas, the average expectation is 64% cover within those, dominated by the species identified there, but with a plus or minus 12% coverage based on the survey that can be explained to you. But there is a better depiction of the types and the dominance, and that is highly relevant to the point we just made, which we're moving to now in dredging and weather monitoring and the like associated with the dredging program. The next slide shows the dredging program. The numbers associated with it are consistent with what we were told last time, but we would maintain, for what it's worth this time, that the dredging program, so far as the bay is concerned, so far as the Port of Geelong is concerned, so far as historical dredging is concerned, is a relatively modest dredging program, and it is also over a short time. Yes, it's 8 weeks or 8 to 10 weeks. So the depiction there is the area and the estimated construction time, coupled with the seagrass mapping. There remains an obligation through the mitigation measures recommended, I think, from this committee last time, that even before that, there's another 12 months of baseline work to be done for the seagrass. There's light metering, and there's a range of checks and balances and mitigations to be put in place live through the program of dredging that are monitoring by availability of seagrass, but it's highly likely you'll hear on the evidence that these indications really emerge in any material way or serious way, significant way for the lands over areas in particular. Now, the next slide says additional work, but I'm just going to leave that as a slide that you can see because I'm going to read you through part of the submission and there are reasons for that. And the following slides will deal with each of your amounts. There's one for threatening migratory birds. All that did is show the locations for the surveys that had to be further analysed by Mr. Rain. We have been going on to send the detailed response for that work. Air quality, we've got the example slide we've given is for the requirement, which was for sensitivity testing and the weight effects. That's been carried out and will be described through this tomorrow on the slide, can emerge. Noise, the other slide we produced for today was to show what are in yellow, which I understand will be those further background noise, monitoring locations, where I'm trying to find locations opposed to the last occasion that were free from existing refinery background noise. But they can all be met as we come back to relevant to those topics. If it's all right, what I seek to do now is move from the slides back to the opening submission. The focusing on marine, as I said, because the way we've structured this, I would like to take you further through the written submission from about paragraph 25, which is page 3. But the purpose of doing this and going through is a little bit long-handed this morning. It's just to say that the supplementary process follows quite specific directions, and we say there is quite a straight line between what was asked of the project and what's been produced. It's not a situation where we say, well, we need to mine or revisit a committee report to ascertain what they thought might be required, because the obligations are quite clearly set out. Secondly, the obligation in this situation was for those works to be part of a study program that was
the subject of consultation with the technical reference group, but this is something which I've already. So in our submission, this is that fault line we described, a case being adequacy fit for purpose for the environmental effect statement, or a case being another way of doing it, or even more information doing it. But it would be inappropriate in our submission to describe what has happened as being anything other than responsive to the direction and the consultation process with the agencies. And I think if you look at general terms at the responses from the agencies, that's important. So I wanted to read through this as it affects the marine environment from page 11. But at paragraph 26, without reading it, is the actual direction for further survey work described through those passages set out there through page 12 and 13, and about which you're familiar. And they get to about 8 directions, which we've described then and given accordingly described as directions 1 through to 8. And then there was the additional work. Now, the additional work, the scope of the additional work relevant to those directions 1 to 8 was guided in parallel by directed procedures to be applied to the supplementary statement. And item 1 of that part of the Minister's directions required the proponent to develop a draft study program to inform the supplementary statement. And this draft study program was the subject of review, comment and agreement by numerous stakeholders in order to ensure that it was sufficiently rigorous to comply with the relevant directions. And it's necessary to consider the background and interaction which led to the finalisation of the study program in order properly to understand that the work that was undertaken in relation to supplementary EES. As the background, on 18th of May 2023, an initial draft study program was developed and provided to DTP Impact Assessment Unit. The 30th of June 23, an updated draft study program was provided, incorporating feedback from the Impact Assessment Unit in advance of the first technical review group meeting that was held. That was held on the 3rd of August 2023. The content of the draft study program was presented to the TRG. In the period between August and September 23, the proponent received comments on the draft study program from the First State, Ports Victoria, DECA Energy, the EPA, and DECA Marine Knowledge Unit. And on 26 September 2023, the proponent provided initial responses and updates to the draft study program to DTP. On 27 September 23, a discussion was held about the scope of the supplementary study at the 3rd TRG meeting. 16th of November 23, DTP provided initial proposal on the scope of the peer review and its cost. 29th November, the status of draft study program was discussed at the 4th meeting of the technical reference group. 7th December 23, the proponent provided an updated version of the study program to the technical reference group, incorporating responding to comments made by the EPA. 19th of January 2024, Stantec, as the independent reviewer, provided its initial comments in relation to the draft study program. And on 6 February 24, a meeting was held with DTP, the Impact Assessment Unit, the proponent, ACOM, CEE and Hydro Numerics to discuss the peer review comments and responses. 15th of March 24, the final peer review report, A, was provided. And 17th of April 2024 confirmed that the 7th version of the draft study program was final, subject to the proponent updating the program to accommodate comments made by Stantec. And 19th of April 24, the study program accommodating all comments was finalised and issued. Now, 2 comments to add to this. I won't take you in the interest of time to the final peer review report A, but the first 6 bullet points of the peer review describe the adequacy of this program. The second point I made about the parallel preparation of this is that you'll appreciate from these dates that at the same time as the program's being developed, the consultants are in the field doing the temperature testing and other work that you saw on the previous slide. So there was, that's why we've described it as parallel. The study program's in draft, but through the technical reference group, there's also discussion of actual things that are taking place at the time. And so as a matter of process, we would say that the committee must be alive to what actually occurred with the agencies, who are the key parties of interest in our submission to for the committee, in understanding whether what the proponent has done is responsive to the directions and adequate for assessment, not some higher test or other test from other parties. And the significance, we say at 29, of this background is that when the IAC comes to assess whether the work in the supplementary EES has been adequate so as to satisfy the Minister's directions, or indeed when the IAC assesses the legitimacy of criticisms as to the scope, nature and extent of those works, the IAC should proceed on the basis of what was in fact done was subject to ongoing discussion and scrutiny, and the finalisation of the study program reflected the combined effort of regulators, expert bodies and independent agencies, and it should be accorded due weight against criticism that others may have chosen to do things differently, which is fine, but it's not what the process produced and was not what was necessary in the particular facts and circumstances of this case. And we say, in terms of the marine environment, consistently with the study program, CE undertook the following additional practical tasks and assessments. And this is a long list, so I'll paraphrase. But there were the towed camera surveys along the shallow water, along the refinery shoreline, and in the Ramsar site, winter, spring and summer. Around 11,300 individual images taken across 15 kilometres of transects in the bay, 3 surveys at 10-week intervals to obtain replicate observations of seagrass cover at each site on each transect, monthly drone images captured of intertidal and shallow subtidal zone at low tide used to assess seagrass habitats. Intertidal seagrass was mapped in 3 seasons using a camera on a drone imagery with over 10,000 high-resolution images collected. Ground truthing of the drone images provided by diver inspections and from the camera images and performed by marine biologists. 6 surveys of water temperature, that's the slide I showed you, in the existing plumes, conducted at approximately monthly intervals to delineate the extent of the existing plumes under various tidal and wind conditions, with the survey methodology adapted to capture that the extent of plumes is largely influenced by tidal currents, which vary on a fortnightly cycle, and whether the wind adds to or opposes the influence of the tide. Chlorine contours calculated from the temperature contours using the known rates of decay of temperature and chlorine with time. The temperature, plume extent and depth profiles were measured using a device which was factory calibrated before use and checked against the reference thermometer each month. A continuous record of water temperature in the Ramsar site was made over a 3-week period using a different device and salinity logger. The temperature and salinity were measured at depth of around 1 metre below the surface. Monthly temperature surveys were conducted at hundreds of points using a sensitive temperature probe and a range of tide conditions in the plumes to map the temperature plumes from the existing discharges in those dates there set out. Mussels were deployed at 6 sites in Corio Bay for 4 weeks, analysed for a wide range of chlorine residuals, including those 3 set out. And in December 2023, seawater samples of 1 litre were collected at 5 sites in northern Corio Bay at a depth of 200 mil and were analysed at Monash University to determine the DNA of fish species present. And at the end of the evidence, and having read the supplementary ES, we'll be asking the committee to not sneeze at the additional work that was done. But the real point is that in this case, and again coming back to the particular facts and circumstances of the case, it's highly relevant that with the additional work, you're getting corroboration, reinforcement of conclusions or findings that were in the EES. If it went the other way, you'd be interested in more. But if you're getting further work, additional work's coming in and it's all tending to the same conclusion, that should give real confidence about the value of the additional information in composite with the original EES work that was carried out. So in terms of outcomes, we say the outcome of the significant work that's been undertaken is set out in, well, the chapter, but technical report A in attachment 1. It will be summarised, not read out by Dr. Wallace in the interest of time, but it is summarised also in his statement. And so then in terms of each direction, we have then set out a response, and I'm going to walk through them without reading the paragraphs in full. But we've set out for each of them the purpose of the direction, and they're pretty clear, and the response. So direction number 1 had a threefold purpose: establish environmental effect of existing discharges, update seagrass mapping to include the intertidal zone information on the different seagrass species, and establish a better baseline for monitoring during and after the project to confirm predicted outcomes on shoreline and benting communities. And we say then from A to E on page 18, we give a response about how, in each case, the supplementary EES has added information from the application of the guideline values, as I showed you with the temperature and chlorine, that the explanation of the dominant habitats of the various seagrass at the various depths, the comparison of those, the distribution, the mapping, and the requirement for a baseline of existing conditions over the 12 months before construction or dredging begins. So that finds its way into mitigation measures, and it's consistent with the reference from the committee. I've just got to check my timing because I've got some other things I need to make sure I'm doing. All right. So what I'm going to do is ask you to look at how we've responded to each of those directions through those next paragraphs, where we provide a specific response based on the additional work and how it's a response to the direction. So in very brief terms, instead by me, you had the hydrodynamics model for direction 2. For 3, an independent specialist provide a prediction of dilution using a different jet model and the predicted dilution of 20:1 matching that turned out to match what had been presented in the previous EES. And that goes also to the assessment of the design guideline values for chlorine concentrations and the temperature. For direction 4, they were the mussel tests deployed near shore in the area of the discharge plumes, and they were collected after a month and analysed for a wide range of chlorinated and brominated compounds, all were at very low concentrations, well below Australian water quality guideline limits. And duplicate mussel samples and reference standards were tested as part of the quality assurance procedure, and that indicated negligible contamination in Corio Bay. For direction 5, an analysis of particles released in the seagrass of the Ramsar site, the same percentage of particles were entrained, 0.12%, the same result that had been established for the EES. No significant change in entrainment rate with the operation of the unit. In relation to direction 6, the sediment size fractions and settling velocities were refined using data from additional boreholes, settling tests and published data on clay flock settling rates. And those concentrations varied over the 8-week dredging program, with the concentration at the highest site averaging 3 milligrams a litre, and the predicted concentrations matched the concentrations measured in an earlier dredging project in Corio Bay and indicated no significant change from the suspended solids predictions in the EES, with a low risk to seagrass health. In direction 7, calculations of available light in the Ramsar site show that for the highest 14-day suspended solids level, seagrass in the Ramsar site will receive more than 20% of the incident light during the dredging program, and the rest over 10% light, and that met the light threshold suggested in the previous assessment. In relation to direction 8, after considering the revised marine modelling, you had to run the model again, the settlement plumes and the revised assessment of dredging impacts on seagrass. It was concluded dredging will not have any impact on seagrass in the Ramsar site, and the results of the EES could be confirmed. And there's a further summary of all of those outcomes in Part A. I'm going to move to a different point now. We say that the work that's been done is material and it is additional. We don't need to prove or have a fight as to whether it is so comprehensive that nothing else could possibly be thought of being done, but we say it's absolutely adequate and material for the conclusions you need to reach about how the environment will change in the vicinity of the refinery as a result of this project. So we then come to 2 points I wanted to focus on, the first being adequacy of material, but the second being a linked point about what we think we understand as being put against us in terms of that. But so far as the adequacy is concerned, we say that at 45 under general observations in our written submission, that given that the scope of your function is defined by the supplementary nature of the process and the plain terms of the Minister's directions and the terms of reference, you're required to consider whether the work directed by the Minister's direction was undertaken so as to enable the IAC to identify the relevant environmental effects and provide an opinion as to their acceptability having regard to likelihood, significance and available mitigation measures. And the proponent submits by reason of the work and analysis reflected in all those materials that the Minister's directions have been met and they are enough to enable you to undertake your function. And the preferable outcome of your exercise of its function will be addressed in our closing submissions. But it's sufficient to observe at this stage that nothing that has been presented to the IAC appears to be, I beg your pardon. It's sufficient to observe at this stage that nothing has been presented to the IAC is sufficient or such that it should preclude you from making findings about the relevant environmental effects. Put another way, you can always have more information, but in our submission, you do not have some inadequate ability based on what you know about that environment or what's before you from making a judgment. And buttressing this conclusion is that the mitigation measures recommended by those other agencies, DECRA and EPA, have generally been accepted, subject to some minor non-substantive alterations to accord with the state of the expert evidence, and also acknowledging that we think we can improve a couple. So the IOU response, the next part of the Part A submission, is really concerned with the matter we dealt with this morning, the extra work, and I'm not going to read through that to you now. I want to go to a different point. But I will just say this, for reasons I said earlier, you'll see that so far as the adequacy review was concerned, there doesn't seem to be a direct link between the subsequent Stantec work and what they'd done before. We understand a different person might have come to the table. We're unable to penetrate that to understand how that could be. But we've put in a document from Dr. Wallace that hopefully even ameliorates much of that, and we can address you about that on the strength of that document. What I wanted to do with my remaining time was just take on this, come back to this adequacy point, and meaning no disrespect to Dr. Edmonds, because there's a lot to be said for more, always knowing more and having more information, but just to demonstrate why in this case it's beyond what's necessary in the particular facts and circumstances of this assessment. And in fact, we don't see it as what we understand is being put forward as being something that was directed by the Minister's directions or indeed suggested by the IAC, but certainly not necessary. And so we've dealt with this at our paragraph 60 and on in the written document. But I might just start by asking Ms. Mann to produce, so that I want to be sure that I'm right about this. And so you need to know how I've understood by reading this what the difference seems to be between Dr. Edmonds and others, or what he's ascertained is necessary, as opposed to what the Minister and others we'd say have ascertained. But if we can go to the IAC's report, there is a useful diagram that was produced by Dr. Edmonds at page 43 in hard copy of the committee's report, that was produced in evidence by Dr. Edmonds, and which I've seen before in other contexts or similar things. And it's a sort of a diagrammatic representation of what you might prepare were one to prepare a full environmental model of an ecosystem. And I just wanted to start this by saying the amount of work, the amount of studies that go into any program of works, or whether it's a management action or a planning action, under any of our legislation, including the Marine and Coastal Act, will always depend on what you're trying to achieve under that act, what you're out there to establish. And the same legislation using the Marine and Coastal Act, where you can get a consent to do works, is also concerned with wholesale planning of coastal strategies around the state. So it's not the case that under the purposes of that legislation, you are always doing the same amount of research work or being interested in every aspect, depending on the purpose of the assessment that's being undertaken. So it would be our starting point that there's no reason for us to dispute the desirability of such a study of an ecosystem, depending on what one is trying to discover. But it's in our submission wholly unnecessary in the circumstances of this EES, indeed many works applications under the Marine and Coastal Act, that one would be expected to be carrying out such an inventory of the system. Our understanding of the committee's acknowledgement of that work is similar to what I've just put. And in the discussion by the committee of your findings and recommendations, and I've had my page and lost it, the committee made a recommendation that was sympathetic to that level of work, but recommended that that might be something to be contemplated in an EMF for future stages and future consideration of the project. I apologise, I've lost my page for that, and it'll be, someone can find it for me. But the point about it is that I wanted to say that taking different or other elements of the environment that might be worthy of future research, or one of them, or an example of it, thank you very much. This is page 44 on the IAC's report, hard copy, where in response to the broader, if you like, inventory, the IAC recommended considering adding a requirement to the EMF to develop a conceptual model for coordinated ecosystem-based management of environmental impacts and risks to the marine environment in subsequent stages of the project, including detailed design, including dredging, operation and decommissioning. Without knowing, I've taken that to mean that over time, it might be of interest in association with monitoring, measuring and assessing the ongoing performance of this facility or any other, to pick and choose other aspects of the environment where you might find it's useful to do a study and add to the information base. And to the extent that's what's suggested, it respectfully appears to be a very sound suggestion, one that doesn't need to be prescribed in the EMF, but could be encouraged. And there might be times where it's useful in years to come to investigate a particular seagrass species or a particular piece of biota or something in the benthic community. That need never be ruled out. It's another thing to say that you had to study every one of those things before you can get your approval. And we didn't understand the committee to invite that. The second thing I wanted to draw about that was it seemed to us that in describing this and before that recommendation, the committee rightly made a reference to the Marine and Coastal Act, which talks about an ecosystem-based approach underpinning Victoria's marine and coastal planning and management system. And I might just get you, can you put the Marine and Coastal Act up? I think it's sections 9. And then now that was a reference to section 9, which we can put on the screen for you, which of course we would invite the committee to recognise is at the highest level in terms of the objectives of the Act, which embraces wholesale coastal planning as well as individual management actions and decisions. And so there'll always be a judgment under that Act or any other Act as to how far do you need to go for a particular approval or a particular assessment. And we would submit that it is wrong to equate ecosystem-based management with what Dr. Edmonds calls an ecosystem model. It depends what tool you're going to use. No one owns that term, ecosystem model. It's not a proprietary term. It depends on your information at hand about the environment in any decision you make. It could come from any number of sources. So we didn't see that there should be some battle line drawn between one set of information being some kind of ecosystem set of information and Dr. Wallace's and everyone else's information somehow being seen as something different. We couldn't quite follow that, and it might just be the way some of the evidence or the material sort of emerged. But in our submission, under the Marine and Coastal Act, you are looking for evidence of the environment, and you'll be looking at it so far as it can to inform you as necessary for your decision, as it informs you about the system. In this case, seagrass mapping is an ideal way of understanding the system, and it has been the way in Port Phillip Bay for many assessments. It's incorrect to say that assessing the seagrass is assessing one thing. The reason the biologists use the seagrass is because of the habitat it provides that inform you from its health about so many aspects of the system. And so these are tools. One of them is not an ecosystem-based approach and the other one not. They are different tools to get a broad understanding of what is going on in the environment and how it might be impacted. Under the Marine and Coastal Act, like every other act and like the Environment Effects Act, decision makers have to make a judgment about what's sufficient information. And in fact, if we can go to section, was it 12, I think? Or 11 is a good example within that act, where it's expressly provided for that act that it's a guiding principle for the management of the marine and coastal environment, that marine and coastal planning and management decisions should be based on best available and relevant environmental, social and economic understanding, recognising that information will often be limited. This is in the same provisions that we understand inadvertently or otherwise. It might be Dr. Edmonds is saying there's only one way of doing this. Doesn't seem to fit very well with the Act itself. It will always depend on what the decision maker needs and what's a sensible judgment and what available information there is. And so in the later witness statement, we see from Dr. Edmonds, his primary criticism, what he calls his key criticism, which is in his, I'm just going from his summary conclusions, it's throughout his report, but I'm in the statement on its front page, the November 2024 statement under summary, which is the first page in under the key conclusions. There was no systematic inventory of the ecosystem features of concern and the potential impact pathways through the ecosystem. And so whether or not that's true, perhaps it is true. We don't have to have that fight of whatever a systematic inventory is, but it's not the question. And so the question through the Minister's directions and for this committee with the EES and this is, what information do you have? Not what information don't you have? And with what information do you have, are you able to make rational, sensible decisions about the impacts or the effects this project's likely to have on its environment? Not some broader environment, not the whole of Port Phillip Bay or something might be of interest to coastal planning strategies, but where it's going to have an impact, because that's what the EES must be concerned with. And so hence, we find ourselves generally in agreement with the agencies about the adequacy of material, but at odds with, again, laudable, perhaps ideal, much broader aims for understanding a systematic inventory of the ecosystem that's in our submission just beyond the practical needs of this process, particularly in light of the particular facts and circumstances of the impacts of this project. So that we needed to say because we don't we would discourage some kind of battle line being drawn up about one set of information being studying the ecosystem and one not. It just doesn't make sense. They're just all tools to collect information about the environment, and your job is to ascertain whether you have sufficient information before you, wherever it's coming from, to make those judgments. In our submission, you certainly do. Certainly, we note that even you'll hear from the EPA later, but on marine, there doesn't seem to be any difference between us and them on these issues. So Dr. Edmonds' journey is his, but it's beyond what's necessary in this case. And that's why we won't necessarily go toe-to-toe on a lot of that with Dr. Edmonds, because we're not criticising that you could do that. We don't need to. We're just saying there's enough here for the committee. The last thing I'd like to do, looking at my time, was just finish our opening by reference to some propositions that we've collected at paragraph 24 of the Part B submission. And they really are just to collect at a very high level where we say after the evidence we expect to return, noting that there will be matters we can improve, provide further detail on, or might affect drafting of mitigation measures and the like. But the first thing we've said about the supplementary process at 24A is that the supplementary EES has produced additional useful information such that there is adequate information for a rational assessment of potential environment effects of the project consistent with relevant legislation and the Minister's directions. The second is that the additional information usefully builds on and in fact reinforces earlier evidence and assessment that the potential effects of the project will not materially increase existing environmental impacts from the refinery and other activities, including to the marine environment. And thirdly, the additional information demonstrates the capacity for the project to comply with applicable requirements and to respond properly to the existing context. And here we're talking about whereby noise from industry is audible from time to time and where it is appropriate to assume ongoing improvement over time. Fourthly, the additional information assists to demonstrate the acceptability of air emissions, what the sensitivity testing's done really ultimately shows compliance. The question that remains with the EPA is really a monitoring question, what the mitigation measure should target around the stacks and or bubble, and we're very happy to continue those discussions. The additional information assists with the resolution of matters concerning Aboriginal cultural heritage between the relevant bodies, and I can come back to that. The additional information generally reinforces the findings of reports exhibited with the original EES, and as such, weighs against contentions that further or other information is needed to predict potential effects to the marine environment or to identify appropriate mitigation measures. And that's the comfort point I made before, or the corroboration point that all additional information has headed the same direction as the EES on critical questions of effect to the environment. And all of the above propositions we say are consistent with the basic locational attribute of the facility, situated within a port setting, attached to a long-standing and entrenched energy facility, and integrated with an existing industrial use of seawater with existing intake and discharges. And where we have emphasised today the significant implications of that being completely neutral in terms of chlorine and a reduction in elevated temperatures as a consequence of effectively refrigerated water entering the refinery, which is currently not the which is currently just ambient seawater. So those propositions we'll return to after all the evidence, Member Carlisle. But we stress for today that there has been a considerable amount of work undertaken since the delivery of the committee's wisdom and the minister's decision on the last occasion. And it would be ill-informed to describe it any other way in our submission or as some kind of flippant gesture. The work's been very deliberate, very careful, very expensive, and very much consulted through with the technical reference group and the agencies. And in our submission, we'll submit by the end of this process, does put the committee in a hopefully in a better position, a surer position, to be confident in measuring these effects and indeed measuring them against the existing environment, which includes those current activities. So unless you had any particular questions from us, that would have been how we close our opening.
Any questions? Any questions from you, Sandra? No? Okay. All right. Well, thank you for that. We'll take our lunch break now, and when we, why have we got a lunch break until 2:30? I think there might be a mistake in the timetable. We'll come back at 2 o'clock. Is that all right? If for you to, okay, right. We'll see everyone at 2 o'clock. Now I have to turn that off, Ken, don't I, when I'm not talking, because it messes up the online audio. Uh-huh. Okay. Just before we go to the EPA, we just do have to have a conversation around the timetable and when we're going to fit submissions in. So if I forget that when we finish for the day, somebody just needs to remind me. Okay. Ms. John, ready when you are.
Thank you, Member Carlisle. EPA thanks the committee for the opportunity to open its case. My instructor has screen shared our opening submissions for the benefit of those online. I don't propose to read them out in full, but I will go to certain parts of them. I just want to use this opportunity to discuss three main things. First, explain how EPA sees its role as a participant in this IAC process, as well as its responsibility to assess the DL applications if it comes to that. Touch briefly on the general environmental duty, or the GED, and how that will guide our participation in this process and our assessment of the EES. And thirdly, highlight the matters, and this is the most important and substantive matter, which is highlight the matters that EPA has identified in its review of the supplementary EES as being relevant to the environmental effects and the DL applications, and about which we have concerns. And I'll particularly focus that discussion on our Appendix 1, which appeared at the end of our submissions, which is just a table which indicates, as at today, which of EPA's recommendations remain open and which have been closed off. The other issue that I just want to touch briefly on before I delve into those three issues is in response to the submissions made by the proponent this morning in relation to the adequacy or otherwise of the supplementary work and the body of science that is currently before the IAC for its assessment. EPA considers that the science underpinning the further work that is contained in the supplementary EES is fit for purpose. So we consider that the IAC has sufficient information before it to discharge its duties pursuant to its terms of reference, and that in broad terms the proponent has acquitted itself of what it was required to do pursuant to the minister's directions. That doesn't necessarily mean we're giving the project a great green light. We do see that there are areas that we have identified of concern to the EPA, and we have addressed that by way of our recommendations, and we will continue to address those through our participation in the process. But we feel that we've had sufficient information to make our assessment of the supplementary EES and to inform those recommendations and to identify the specific concerns that we have within our remit. I should say that none of that should undermine or be seen to derogate from the ability of any other submitter before this IAC to make any submissions it seems fit to make about the adequacy or otherwise of the science. But I'll leave that there for the time being and now go on to the three issues that I identified. So just turning first to the EPA's role in relation to this IAC process, and we deal with that at paragraph 6 and 7 of our submissions. So our overarching objective in participating here is to assist the IAC in understanding our view on whether the likely effects of the project on the marine environment, noise and air quality have been properly considered in the supplementary EES, and including whether they've been appropriately avoided, mitigated or minimised in the EMF in a manner that's consistent with the GED. And I note there that we've only referred to some of the relevant environmental effects that this IAC is to consider, because not all of those fall within EPA's remit. We're also here to assist the IAC in understanding any new information that's arisen in the supplementary EES, which is relevant to our assessment of the DL applications. And as we say at paragraph 7, a guiding principle of our participation is the importance of taking a proactive approach to preventing risks of harm to human health and the environment from pollution and waste. And that really is a principle that's reflected in the GED, which we go on to deal with in more detail. Now, paragraph 35 of our submissions, we make some observations about the context of our participation in this IAC process on the one hand, and then our responsibility to eventually assess and determine the DL applications if it gets to that on the other. And I just wanted to emphasise those points for present purposes and say that the EPA has not reached a final view in respect of the DL applications. Its ultimate determination having regard to the matters it must consider, and ultimately to the question of whether the proposed activities pose an unacceptable risk or risks of harm, will be informed by the committee's advice and the minister's assessment of the environmental effects of the project, together with the matters that are prescribed in the relevant legislative regime. As a decision maker, we must not fetter our discretion in relation to the DL applications through this IAC process. And so our submissions here should be understood as being preliminary observations, really, which may change as we undertake a more detailed assessment of relevant material. And no part of this submission should be relied upon as being indicative of our final views. Having said that, we have obviously made a real effort to identify any clear issues as soon as we can, and we are going to try and be as transparent as possible, but that point does need to be emphasised. So now I just want to, moving to the second point, I just want to touch briefly on the GED and how that will guide the EPA's participation in this process and its position on the issues. So we deal with the GED quite comprehensively in Part B of our submissions, which start at paragraph 13. So I just want to emphasise, I'm not going to go into these submissions in detail, but the GED applies to any person who's engaging in an activity that may give rise to risks of harm to human health or the environment from pollution or waste. So in the context of this project, it requires and would continue to require persons engaged in the design, construction, operation and decommissioning of the project to minimise the risks of harm to human health and the environment from pollution and waste, through eliminating those risks so far as is reasonably practicable, and where elimination is not reasonably practicable, the reduction of those risks. So this shift to the minimisation of risks or of adverse effects to whatever degree and duration displays this more historical approach where you assess a project on the basis that, you know, an acceptable outcome is achieved just by complying with standards, or where you're allowed to potentially pollute up to a limit. This allows us to, that generally isn't considered to be consistent with the GED. It's not consistent to adopt a focus on criteria or targets or levels. Rather, what the GED seeks is to encourage duty holders to adopt a preventative approach and to reduce risks of harm to human health and the environment so far as is reasonably practicable. It also should be emphasised that GED is a continuing obligation, and so it's necessary to have iterative processes in place in the course of the design, construction and operation of a project to make sure that you're continually checking in with your obligations in that regard. Just by way of final remarks on that small topic, we say the cumulative effect of the operation of the GED in the context of this project, and particularly when you're looking at the EMF that's being discussed as part of this supplementary EES, is it needs to be considered through the lens of the GED. So our recommendations seek to ensure that the mitigation measures that are in the EMF are consistent with the proponent's duties under the GED, notwithstanding that it's an independent statutory requirement with which the proponent will need to comply. Yes, the EMF will provide a critical framework for the continued identification, assessment and control of known and emerging risks. And our role here is to ensure that the EMF is as robust as possible, but it also cannot exhaustively deal with all the risks of harm to human health and the environment contemplated by the GED which may arise during the project, nor will it necessarily prescribe how those risks can be minimised in accordance with the GED. So the assessment by the Minister for Planning, and in particular the assessment of the EMF, will not amount to a determination that the proponent is compliant with the GED, since the EPA is the independent statutory authority empowered to monitor compliance with that. So the GED imposes ongoing obligations on the proponent as a duty holder, which are not static at the point of preparation of the EMF. That's not to say that we've seen anything in the proponent's materials that suggests that it has a different understanding to us about that, but we just seek to make that point clear at the outset, that that's the lens through which we're looking at the EMF and where we're coming from when we make recommendations and seek to make amendments to the EMF framework. So now I'll just turn to the final topic that I wanted to deal with, which is, as I said, the most substantive issue, which is, well, what is EPA's position as at today in respect of the relevant environmental effects and the matters relevant to the DL applications that are arising from the supplementary EES? And I'll try to do that with reference to our appendix document. And I'll deal with that in sort of order of by topic rather, and I'll try to focus mainly on the recommendations that remain open, because obviously that's going to be the focus of things moving forward. So I'll deal with marine first. So our marine recommendations are recommendations 1 through to 3. And as I noted at the outset, and this is reflected in paragraph 45 of our submissions, we note the further work that the proponent has undertaken to mitigate the environmental effects of the project on the marine environment, and we're satisfied with the rigour of the studies that have been undertaken as part of Technical Report A. So our recommendations in the space of marine are more directed at increasing the robustness of the EMF and to ensure it accurately reflects the GED. We do note that there are still outstanding marine issues which are pertinent to the DL applications, which we expect to be the subject of further discussion with the proponent, and that is particularly in relation to recommendation 3, which I'll get to. I won't spend much time, so now turning to the actual recommendations, I won't spend much time discussing recommendation 1 because that was responded to by the proponent through supplementary technical note 3, so EPA considers that to be closed. Our second recommendation, the intent behind the recommendation was to ensure that the EMF provides for a monitoring program that assesses the operational impacts of the project. As I understand it, I think the way in which that recommendation was initially framed may have caused some confusion and may have caused the EPA and the proponent to be at somewhat of cross purpose, because I think we initially suggested that amendments be made to the mitigation measures dealing with dredging, but we're rather focused on ensuring that there are mitigation measures in place that assess on an ongoing basis the impacts of the project's operational phase on the health of the marine environment generally. So to sort of remove the possibility for further confusion, we've amended our recommendation, amended recommendation 2, and that basically seeks for there to be for the operational impacts to seagrass and plankton to be measured and where possible mitigated as a separate mitigation measure. And we recommend that the proponent identify suitable thresholds based on baseline monitoring of seagrass and plankton. And paragraph 58 of our submissions directs the proponent to what we consider should be that mitigation measure should be focused on. But that's our underlying intent in making that recommendation. So we hope that that clarification assists the proponent in reaching a position on that recommendation. Now, recommendation 3 is more relevant to an assessment of the DL applications rather than being something that arises purely from the work that was undertaken as part of the EES, supplementary EES. So part of what the proponent was required to do in the supplementary EES was provide a detailed assessment of the effects of existing chlorine discharges. And we note that they've done that, but that further study doesn't necessarily specify what other chemicals are going to be added into the cooling water system within the refinery. And from wearing our DL application assessment hat, that's an essential question for us to understand what, if any, chemicals will be added or amended, including dosing rates or concentrations to the FSRU cooling water that circulates through the refinery. And those are important so that we can determine make an assessment of impacts, but whether there'll be any necessary consequential amendments of the existing refinery operating licence. So I expect that there may well be some information in that regard that comes out as a result of this process, but we're still considering our position in that regard, and we may choose to deal with that by way of a further request for information under 51A of the EP Act. So turning now to air quality, we make again 3 recommendations on the topic of air quality, and those are recommendations 4 to 6. I can happily say that recommendations 5 and 6 are closed, so for present purposes we're only focusing on recommendation 4. At its heart, recommendation 4 reflects the EPA's concern with the imposition of bubble limits for the project. As we understand it, the proponent's current ask is for a combination of annual bubble limits and stack-specific emission limits. And as I say at paragraph 67, the EPA holds concerns in relation to the imposition of bubble limits as limits for this project, but particularly so since the introduction of the EPA Act, and particularly so since more information about the impact of the GED and that shift in focus, what that actually requires and means for duty holders. So as we know, bubble limits are applied annually across a whole facility. And so they have an inherent nature to potentially hide excessive emission peaks over short periods of time at specific locations. And those peaks can result in adverse effects on the community. And so by their nature, they can lead to an overestimation of emissions, and they don't incentivise, in all cases, a minimisation of emissions, so far as is reasonably practicable, which is what is required by the GED. Also, sometimes they can enable a very high pollute to limit, which, as I adverted to earlier, is now inconsistent with this new approach that the GED calls for. So our concern is that whilst the proponent has currently proposed a combination of stack-specific and bubble limits, our concern is that the bubble limit would potentially permit the proponent to operate at peak load, even for more than the estimated 6 days per year contemplated by that operating scenario, provided that the overall annual emissions don't exceed the bubble limit. And that's a situation that causes some concern for the EPA in terms of compliance with the GED and making sure that you're always reducing emissions so far as is reasonably practical, and that there's always incentive to do so. We consider that prescribing stack-specific emissions limits for this project is more appropriate. It provides more transparency and accountability in terms of the emissions that are actually generated. And that's particularly the case here where we're talking about an FSRU which has emission or stacks which are quite easily able to be verified and discerned. You know, I think the models that are before us have 4 engines and 2 boilers. We're not talking about a very large number of discharge points that the EPA sees in other types of licenses, where it's very hard to figure out what's coming from what stack. And so, you know, there's a convenience, I could say, with imposing a bubble limit. Here we have very clearly defined emission sources, so we think a stack-specific emissions approach is appropriate. It's also more consistent with the GED because the proponent will be consistently incentivised to reduce those emissions so far as is reasonably practicable, and it will also facilitate accurate verification of compliance with the limits at any given time. Now, the way our recommendation 4 is currently worded is that we sought some further sensitivity analysis from the proponent. And we just asked for some more information about the way in which they had calculated their stack-specific limits. My instructions are that the EPA doesn't consider that further sensitivity analysis is required. We consider we have enough information based on the worst case scenario that we've been provided with the stack specific limits in the supplementary EES to go away and figure out what the likely emissions would be in a stack specific scenario. But I've still recorded recommendation 4 as being open because I think there's still an ongoing discussion about, you know, the bubble limit versus stack specific limit that I think will need to come out through the evidence. But I just wanted to be upfront about what EPA's position was in that regard. So as I said, recommendations 5 and 6 on the area of air quality are closed, so we can move along. Yes, of course. Yes.
Sorry. I'll just start again. Before we move off air emissions, can you just explain why a stack specific limit incentivises driving down emissions more effectively than a bubble limit?
Well, a stack specific limit would be imposed based on a true understanding of the actual operational requirements of the FSRU, first of all. So it wouldn't necessarily permit all engines to be operating at 100% load all of the time, i.e. in that peak load scenario. And it would also provide a clear and discernible limit as to, well, this is the maximum amount of emissions that can come from that source at that particular time, regardless of what demand is, or regardless of whether or not in the past you've been below that limit. It won't give you space to go over that limit in the future because it's based on each stack source rather than being an annual limit that covers all of the sources cumulatively.
So you can't go hard on one stack for a period of time and think I'll catch up on my bubble limit by the end of the year.
That's right. That's right. And I think that the EPA is prepared to consider a licence condition which does reflect the operational requirements for the proponent in terms of meeting seasonal gas demands, but it considers that can properly be done as an adjunct to a stack specific limit rather than a bubble limit for all of the stacks that is applicable as or expressed as an annual limit.
So a stack limit is not expressed as an annual limit?
It may well be expressed as an annual limit. It can have different modes of expression. It may well be expressed as an annual limit, but it will be expressed as an annual limit on the basis of a true understanding of the actual operational mode that the FSRU expects to take in the course of a year.
Okay.
Yes.
Follow up. I'm not sure whether I'm going to word this correctly. Is the EPA satisfied that you're aware of the stack limits at the existing facility under current operation?
Are you talking about the refinery?
Yes.
I don't have instructions on that. Can I take that question on notice and get back to you?
Certainly.
Thank you. I should say that I'm aware that currently there is a bubble limit that applies to the refinery as well. So, but I will go and seek some instructions as to, in relation to your question, and how we have a sense of what their emissions rates are and compliance.
So where I'm trying to get to is you're seeking to have stack limits for the new infrastructure.
Yes.
Are you across what's happening with stack limits on the rest of the infrastructure?
Yes. Thank you.
But the bubble limit, I'm going to follow up on the follow-up. The bubble limit would just be for the FSRU.
Yes.
It wouldn't be for the FSRU plus the refinery.
That's correct.
Yep.
Yes.
Okay,
yes.
Gotcha.
Yes. Okay, so moving now to noise. Okay. So the EPA makes 13 recommendations in relation to noise. They're recommendations 7 to 19. So recommendation 7 of ours relates to the imposition of project noise criteria. And those are recommended in Technical Report D, and they're set 10 decibels below the noise limits. Overall, we consider that to be an acceptable approach to ensuring that the project doesn't contribute to cumulative noise exceedance. We understand the proponent is generally in support of project noise criteria, but there seems to be a dispute between the EPA and the proponent as to how those project noise criteria are used, whether they're purely a design tool or whether they ought to be reflected in the EMF and used as a enforcement tool once operations are up and running. The EPA's view is that it's appropriate to have those project noise criteria recorded in the EMF and used as an appropriate enforcement tool. We also note that the evidence of Mr. Evans, who's relied on by the proponent, supports project noise criteria in principle, but has adjusted project noise criteria in several manners. We have some concerns that his adjusted project noise criteria are potentially inconsistent with the GED. And the requirement to ensure that noise from the project is reduced so far as reasonably practicable. So we expect to tease some of that out when we hear from him. In terms of recommendations 8 and 19, they relate to dredging noise and the requirement that dredging noise comply with project noise criteria. EPA's initial position was that dredging noise ought to comply with the project noise criteria, although we've reconsidered our position and we no longer make that recommendation. We accept that there's a distinction between noise generated by dredging, which is temporary, and a one-off activity, and that's generated by the project. We're of the view that only project noise ought to comply with the project noise criteria. So we don't press those recommendations in their original form, but we do say that some amendments to mitigation measure NV04, and I should say paragraphs 90 and 91 refer to NV05 where it should be NV04, so I apologise for that error. But we say there are is a small tweak necessary to that mitigation measure to really ensure that it properly mitigates against the potential adverse impacts from dredging noise, and that is to explicitly include the requirement that where there are assessments that are conducted in accordance with EPA's publication, the noise protocol, which indicates that there is likely to be contributions from dredging that exceed the evening or the night period, that it's amended to include the day period as well. And this, we say, accurately, this amendment should accurately reflect what we understand to be the proponent's intent, which is to cease dredging where there are assessments made that indicate there are likely to be cumulative noise exceedances. Now, coming to recommendation 9, that focuses on the choice of background equivalent location for Geelong Grammar School. So we understand that the background noise levels recorded at the school were influenced by intrusive noise, and so pursuant to the protocol, an equivalent background location needed to be chosen. The EPA is of the view that the information contained in the technical report and further substantiated by Mr. Evans' evidence still doesn't provide an adequate justification, or there are still a lot of unanswered questions in relation to the choice of background location. So we expect to test the evidence on that point.
Now that's the noise monitoring point.
That's right. That's right. So the technical report chose BG4 as a representative background location or equivalent background location. There were other potential choices. We're not necessarily saying it was the wrong choice or that another choice definitely ought to have been made. We're simply saying on the information available to us in the technical report and in Mr. Evans' expert report, we're still unsure. We still have some unanswered questions about that choice. And of course, the choice of background location then has implications for the calculation of the noise limits. So if the chosen background location or the chosen equivalent background location is inappropriate, i.e. if it's too noisy or noisier than Geelong Grammar School, for example, then that has impacts for the way in which the noise limits have been calculated, which in turn has an impact on the project noise criteria. So it's a flow-on effect. It's a bit of a domino effect, yes. Recommendation 10 refers to the values of the noise levels and meteorological data reported in B3 and B4 of Appendix B. It's not a substantive recommendation. It's simply, I think, the EPA has requested some further information from the proponent. The form in which we received that further information hasn't allayed all of our concerns, or it hasn't been able. It hasn't been possible for us to properly interrogate that information in the form in which it was provided. So we've used our opening submissions as an opportunity to clarify our ask, shall I say. And so we're hopeful that we can receive some information from the proponent that in the form that assists us. Efforts were made to respond to that recommendation. We just haven't quite gotten to a point where we've got what we need, but I'm sure that will be forthcoming. Recommendation 11 relates to the revised noise modelling that was undertaken, and it appears at Appendix C. At a very broad level, we understand that there's been a reduction in conservatism in the model, and we just have some concerns that hasn't been adequately quantified or doesn't appear to be discussed in Appendix C or elsewhere. So we've sought some further information on that. We're currently considering our position on that, and we may request some further information from the proponent in the course of the IAC hearing. We're just trying to be as particular as we can about what it is that we are concerned about, and therefore what it is that we're looking for, so we can give the proponent the best chance to provide us with answers to those concerns. We may well, yes. We haven't made a decision one way or another yet. We're still trying to determine precisely what it is that will assuage our concerns in that regard, and then we can turn our mind to what mechanism may be the most appropriate to use. Recommendations 14 and 16 relate to Annexure 1, which is the noise assessment, mitigation and contingency measures. Recommendation 14, again, it relates to the conservatism inherent in the modelling there. Again, we understand that it's not a very straightforward or ask that's easy to express. So again, we're going back to basics and trying to clarify what it is that we're looking for, and then we will turn our mind to what mechanism we need to utilise to get that information from the proponent, whether we do that through the IAC process or through a further request for information. We also, recommendation 16 requested further information from the proponent in relation to the contingency measures in Annexure A. So the proponent provided that discrete information. So in that sense, the recommendation is closed. But considering the shape of the expert evidence as it stands in relation to the adequacy or otherwise of Annexure 1 and the difference in views between Mr. Evans and Mr. Tardio in that regard, the EPA is still considering its position in relation to our views on the overall adequacy of Annexure 1. So whilst recommendation 16, that discrete information has been provided, we do reserve our right to raise any other issues or concerns that we have in relation to Annexure 1 and how it proposes to further mitigate or attenuate the noise generated by the project. The final recommendations listed there at paragraph 120 are all closed. So that is very simple answer in that regard. The final section of our submission just clarifies our position in relation to the updated planning scheme amendment, which is that our concerns have all been adequately covered off. So those were the matters that I was proposing to take the committee to by way of opening, unless there are any further questions that I can assist with.
Member Briscoe, did you have any questions for the EPA? Nope. Yes.
And I've taken your question on notice, Member O'Neill, and we'll come back to you with a response to that as soon as possible.
Thank you. And I've got another.
Yes, certainly.
I think in about 3 different instances, just then when you're going through the recommendations, your default position that you expressed was that you may seek further information from the proponent as part of this process. When do you think you're going to put those questions to the proponent to be fair for them and us in being able to have the information in a timely manner to respond?
I take your point. We're hoping to do that as soon as possible. Ideally, we would do it before we make our substantive submissions to the committee, so that we can reach a concluded view one way or another on where things stand at the time of making those submissions, and also so that the proponent has adequate time to deal with those responses as they see fit before they make their own submissions.
I think that would be great. I mean, it's what we look for at the end of one of these processes is as few loose ends as possible. So if you're able to do that work up front, so we can have that fleshed out through the main submission, that'd be much appreciated.
Certainly, yes. It's also our preference for there to be as minimal loose ends as possible. So hear you loud and clear, that's not a problem.
Okay. All right, next up we have DCAR. Is Ms. Cluning on the line?
I am Member Carlisle.
Okay, hi Ms. Cluning. Now we've got a written opening submission from you that was filed last Friday as well. So we'll hand over to you to take us through that.
Thank you very much, Member Carlisle, and thank you for the opportunity to speak today. I think I've got some feedback on the line. My apologies.
You're sounding
It's not coming through to you, I'm guessing.
You're sounding okay at this end.
Okay.
There's feedback coming through.
Oh, well, let's see how we go, hey? Oh, it seems better. So I'd like to start today by acknowledging the traditional owners and pay my respects to elders past and present, and also acknowledge other government departments and community members who are presenting submissions to the committee. Before I get into detail, Member Carlisle, I'd like to clarify that DECA Regions has provided a submission during exhibition, which raised a few matters, including seeking clarification of native vegetation removal. The proponent has since provided a detailed response to DECA's submission, and DECA Regions have reviewed this response in preparing the submission that we talked about that was circulated last week. I note at this stage, DECA Regions do not have anything to add to the written submission. I assume in some way that the written submission that we've can be taken as read by all parties, but today I'll run through that submission as a summary. Before I do, Member Carlisle, can I just check that there's anything in particular you'd like me to address or clarify as I run through the submission?
I don't have anything specific. I'll just check in with my other members as to whether there's anything specific. No. Okay, we'll leave it with you, Ms. Cluning.
Thank you very much. Nice to clarify that up front, I think. DECA Regions acts as a referral authority under the Planning Environment Act with delegation from the Secretary of DECA. With relation to this project, provides advice relating to marine and terrestrial flora and fauna, threatened and migratory birds, and other biodiversity matters considered as part of assessments for environmental impacts. Under delegation from the Minister of Environment, DECA Regions has delegated authority for the Marine and Coastal Act 2018 for coastal Crown land, which is the outer limit of the Victorian coastal waters, or 3 nautical miles, and 5 kilometres inland of the high water mark to a depth of 200 metres below the surface of the land. And the Flora and Fauna Guarantee Act 1988 to enable and promote the conservation of Victoria's native flora and fauna and the management of potentially threatening processes on public land, including Victorian state waters.
Could just pause for a second there.
I'm just informed that people who are watching online can't hear the submission.
Ah, okay.
And obviously,
We're just having some audio issues with our online observers. That the audio quality is not great, so we're just getting Ken to see if he can weave his magic. Ken, would it help if we all turn off our?
No, the issue is inside Teams at the moment, so I think what I needed to do is to turn the sensitivity of the microphone down a little bit, but that's an extensive process I need to go through with it. So
Oh, okay. So that's not something we can do right now on the
that's
spot.
something we can do right now, no.
Okay. Just bear with us, Miss Clooning.
Could you just ask her to talk for me, please, Sarah?
If you wouldn't mind just saying a few words so we can test. No. No. Well, that turned bad audio into no audio. So
Is she talking at the moment?
could you try again, Ms. Clooning?
I can keep talking. How does that sound? Is that any better?
It's good in the room. Perhaps we can get you to check with whoever's online observing to see whether. Okay. Let's. Much better. Okay. There you go.
Oh,
Ken.
excellent. That's wonderful. It's good to see.
Right,
Thanks
so
for helping too. That's appreciative.
Okay. Over to
Okay, so finally today, DECA Regions has taken part in the EES and supplementary process by providing advice to the Department of Transport's Impact Assessment Unit regarding the project's initial referrals under the EES Act, Environment Protection and Biodiversity Conservation Act, and involvement in the project's technical reference group on matters which were regarding potential project impacts on biodiversity and public land. Checking. Now let's move to the submission detail. Following the supplementary EES documentation being publicly exhibited, DECA Regions made a submission to the inquiry on matters relating to clarification on proposed extent of native vegetation, including seagrass, to be removed and evidence of availability of offsets to meet the requirements of the Native Vegetation Guidelines, and strengthening the Environmental Management Framework, or EMF, which the EES relies upon to mitigate potential impacts. The proponent has clarified the extent of native vegetation proposed to be removed and provided evidence of offsets, satisfying this component of DECA's exhibited submission. DECA Regions have found that the project adequately avoids and minimises impacts to threatened and migratory birds, subject to the preparation of the EMF within the incorporated document. The supplementary EES relies on the Environmental Management Framework to mitigate potential impacts to marine environment and retained native vegetation. We support the preparation of a detailed EMF as a requirement of the draft incorporated document, and I wish to acknowledge the proponent's response to our submission, where they propose to include trigger values and actions relating to ME06 and ME19 in the OEMP. Also proposed adding sentences to ME20 and update the CEMP to outline the species to be planted, monitoring for success, and including trigger values and actions if outcomes were unsuccessful. And the proponent has also agreed that pre and post monitoring findings in relation to the marine environment will be provided to DECA and other relevant organisations, and made a suggestion that this be included in a Marine and Coastal Act consent. Recommends for consistency that the agreed inclusions should also be incorporated into the overarching EMF. And that relates a little bit to the recommendation number 2 for the EPA as well. The inclusion of trigger values and actions to the EMF will provide a direct relationship with the impact and the risk mitigations. Also, to mitigate potential impacts of the project to native vegetation and the marine environment, the EMF, including the CEMP and OEMP, be prepared in consultation with DECA. So finally, in conclusion, DECA Regions does not have any outstanding concerns and is comfortable that any potential impacts that remain will be adequately managed through the preparation of the environmental management plans as a condition of the planning approval. DECA Regions does recommend that the proponent's changes are accepted, but strengthened by including the changes in the EMF in the incorporated document as outlined, and that DECA Regions are consulted with the preparation of those documents. Thank you, Member Carlisle. And any further questions?
Thanks, Ms. Cluning. Just when you say that you think that things could be strengthened by including these requirements in the EMF as well, the mitigation measures form part of the EMF. So what, in addition to the changes to the mitigation measures, are you looking for?
We're just looking for those triggers to be added into there so that if there is an unforeseen outcome, that there are triggers and that will put that back into a better situation.
Okay, that's a fairly high level and general
Yes.
principle. So rather than us trying to guess what words you're looking for,
we need to provide those.
Yeah, we
Sure.
need drafting from you.
Yes, we're happy to provide drafting, and I'll take that on notice for you and provide that.
Okay, great. Thanks, Ms. Clunie. I'm just checking in with our members as to whether they have any questions for you. Member Briscoe? Yes. Member O'Neill's got a question for you.
Thank you.
It's a good segue from what the chair's just taken you to, but at your paragraph 12, under 4.2, threatened and migratory birds, you state that DECA Regions has found that the project adequately avoids and minimises impact to threatened and migratory birds, subject to the preparation of the EMF. It'd be handy to know what that entails. I'm not sure that the EMF actually goes to the topic of threatened and migratory birds in that context. So I'm just unclear about what you're suggesting. Do you have anything off the cuff that you can provide, or do you want to take it on notice?
Member O'Neill, I will take that on notice, not my area of expertise, and I'm happy to provide those two details to the committee.
Thank you. And further, and again, this may be just something to alert you to, the committee's going to put to Mr. Lane tomorrow a couple of questions relating to the Greater Geelong City Council submission in relation to, so that's submission 316, in relation to threatened and migratory birds and the adequacy of the investigations. So just flagging that you may want to listen in, and you may have a follow-up question as well, or response.
That's terrific, and I'll definitely be listening in. Thank you.
Okay, thanks, Ms. Cluning. We also wanted to just check in with you as to whether you think you'll need, we had a half-hour slot for you in the timetable. I think it might have been on Thursday this week. Our timetable is a bit of a moving feast at the moment. But do you think you'll need any further time to make substantive submissions?
No, I don't think there'll be any need for that.
Okay, great. Thank you. Okay, next up we have the school. Do you want to have a quick break, or are you happy to just go straight into it?
Go straight into it.
Okay.
First, thank you for the opportunity to make a brief opening in this matter. I don't propose to introduce the school to the committee, given that the history of the matter and the fact that the school has been a significant participant in these processes along the way. We've either asked for or been provided with the opportunity to address you for 30 minutes. I think it'll be a lot less than that. We've deliberately tried to be economical because, to our way of thinking, the matters to be framed before you are relatively straightforward. We want to start by saying that we appreciate the IAC's terms of reference and we appreciate the directions of the Minister. Our friends in their opening written submissions have spent a lot of time sort of explaining what that is, and I'm not sure that there'll be much difference between us, or if there is much difference that matters in the end. Ultimately, what we say is that what's before you is a factual inquiry. And it's the same sort of inquiry that you're engaged in 2022. We accept, in saying that you are obliged to examine here the relevant environmental effects of the project. But just like in the EES, to do that, there are two critical things that need to be understood. And we don't take the directions of the Minister or your terms of reference to in any way intrude upon a framing of that inquiry in this way. The first thing is, what is the condition of the existing environment? And a subsidiary question there is, has adequate work been done to describe or understand that environment? And second, what is proposed? And that involves an understanding of what works are required or processes and what impact they will have on the environment. Now, those questions arise here in relation to the relevant environmental effects in more or less the same way as they arose the first time round, because of the wholesale inadequacy of those inquiries at that time. Now, of course, it's important to say also that you obviously don't make a decision. What you're doing is making a report on those technical matters and an assessment of those environmental effects to facilitate the assessment of the Minister, and your report will be used to inform what the EPA might do and other decisions that are made under separate legislative frameworks. Of course, it's important though, because when the environmental effects statement is produced ultimately, the fact is we don't have a say when the EPA comes to consider an application for a development licence. So it remains of concern to us, as it did the first time round, that there are elements that are relevant to not only the acceptability of the project, but also what conditions might be imposed to control the project, because we won't be able to participate then if the project moves forward. We agree, and having heard the submissions of our friend, we want to be explicit about this. We agree there's a difference between your task on this occasion and what you did the last time. It's not free-ranging, and we hope that we've been clear in our written submissions and in the way we've approached our evidence, and in particular, the way we have instructed our witnesses to focus their attention on the directions and whether or not the work has been done to meet those directions. We want it to be clear that, for example, you will not hear us making arguments about whether these facilities are necessary. You'll recall last time we called economic evidence about those matters. We haven't sought to put that on this time. You will not hear us making submissions about whether the VOPAC proposal is better. there will be competing projects. There have been a history of competing projects. One was mentioned earlier today, the Crib Point 1. The Vopak 1 has been sitting on the sidelines for a while, but has recently been reignited. Which of those approvals, which approval is given, which site will be the better one, which one wins the opportunity to do it, will be a matter of judgment for others. We agree that the real question here is whether this location is a good location for this activity having regard to its environmental effects. Or put another way, are the environmental effects of the project in this location acceptable? And I think in that respect, subject to how arguments are explored in detail later, there might be some agreement about that. A subsidiary question, though, is have those effects been adequately assessed? Now, the starting point might be to ask rhetorically, why are we here? We are here because in 2022, the IAC found that the assessment of the effects was inadequate in critical respects. We are here because the Minister has agreed to give Viva another opportunity to fill the gaps in that assessment. We accept that that assessment wasn't inadequate in every respect, but it was inadequate as it addressed some of the fundamental aspects for a project of this kind. This is a project about ships and dredging and emissions to water, which on the face of it gives rise to questions about marine ecology, hydrodynamics, and these were seriously deficient on the last occasion. We do not intend to reprise what you said in the EES report, but we wish to make the point that the Minister's directions are not to be read in a vacuum. They have a context. Indeed, the Minister's directions embrace the 2022 IAC's articulation of what was deficient and articulates the tasks to be done based on that. Of course, apart from the marine issues, separately, there was the noise issue. And the noise assessment, which had been done before you on the last occasion, I'm just going to simply summarise, hadn't been done right. Indeed, to be clear, it was common ground on the last occasion that significant work was required across a range of things. We agree that this is not a new EES, and it's not an opportunity to reopen matters outside the relevant environmental effects that have been defined. But those relevant environmental effects, while limited, are central or fundamental to this project. And what's really happened here is that Viva's been given the chance to fill the gaps that you identified on the last occasion. You'll see from our opening submissions and from the evidence that we attempt to constrain ourselves to the directions and those relevant environmental effects. Our case is that the SEES doesn't adequately respond to the Minister's directions. Now, it's interesting, it has been interesting to hear the proponent lay out in chronological detail the formulation or the process of the formulation of the what's said to be the stringent study program, starting with how the issues were identified and all the different agencies were involved. How it was a product of various agencies' work over many months. There are really two things to say about those submissions to put our case in context. The first is that there is a difference between the Minister's direction and what the study program and agencies subsequently agreed would satisfy those directions. That's the first thing. And we just want to put that in context as well. You'll remember that at the first EES, the project went through a similar process and it enjoyed support from the TRG and from various other agencies. Ultimately, whether the study program was stringent or not is a matter for you. It's not to be taken as some kind of starting point. Oh, well, they've decided that there's this stringent study program and that's the starting point and that should be given weight. That's not correct. Not to start on the assumption that the agency's views about adequacy is correct. That's for you, and indeed, if that were right, then all of your findings the last time are wrong because they all came to you the last time and said that the study program was thorough. The next issue is whether or not what's been done adequately fulfills what's said to be this stringent study program. And we'd simply say this, it has to be said that a good study program is not necessarily the same thing as a good study. It's to be noted that this project was first exhibited in 2022 with similar endorsements and including from the Impact Assessment Unit. It's also to be noted that the relevant agencies here are not all in agreement about the adequacy of the outcomes of the study. And indeed, you heard submissions from the EPA who will be an ultimate decision maker using this report as a tool, if it ultimately comes to that, to inform its decisions, expressing concerns about some aspects of the material that's before you, including in relation to noise. We are right now where we are in terms of the flow of evidence. I haven't caught up with whether or not there is presently underway a conclave for the hydrodynamics witnesses. I think what Mr. Townsend said earlier today is correct. It was either going to happen today, or if it didn't happen today, it was going to happen between 12 and 3 tomorrow. So I'm going to park what I'll say about hydrodynamics at this point. As to marine ecology, we agree with our friend, we should not draw false battle lines. It seems to be said by Viva that Mr. Edmonds' approach to the question of analysing marine ecology is in some way extreme or disproportionate, having regard to what's required to be considered in this case. It's of note that that's what was said of him the last time. Ultimately, whether what he does or says or suggests and its adequacy or appropriateness is a matter for you, Dr. Edmonds will give his evidence in due course, and we're not going to précis his evidence or attempt to address any potential future attack. Really, you should just hear his evidence, and he's been directed precisely in the questions to him to what the directions required, and he's given his evidence about that. In relation to noise, we would say that we note the position of Viva that it is not advanced in opening its noise case. We don't have a problem with that. It's not apparently going to address, we're not going to address that matter in detail either. We note what seems to have happened in relation to noise with interest. We note in particular that the evidence of Mr. Evans departs from the exhibited EES in a couple of significant ways. And we anticipate our friends will put on some written submission and address you on some legal issues, and I don't want to preempt or gainsay them. I want to hear them and address them in turn. It's foreshadowed in the written submissions that the noise, and foreshadowed this morning that the noise submissions would be produced on Wednesday. I'm just not sure whether they're going to be produced at 12 noon the day before or whether they're going to be produced the morning of the cross-examination. It would be obviously better if they could be produced sooner because, well, for obvious reasons. In relation to noise, I'm able to say that largely as exhibited, the EMF and the way it seemed to approach noise addressed some of the concerns of the school well, and that some of the changes suggested by Mr. Evans are of concern. You'll recall on the last occasion that there was a lot of confusion about what the sources of noise were and what contributions they made. I think it would be fair to say that leaving that hearing, the expectation was that those noise sources would be properly identified and addressed, and they seem not to have been. We would like, the school would like in relation to noise for the EMF to deal with this question once and for all, and we think it's appropriate that it does. Now, if it pleased the committee, that's all we wanted to say by way of opening. We adopt our written statement. But as I said, this is largely a factual inquiry, and the issues that we raise will be explored in the evidence.
Thanks, Mr. Finanzio. Any questions from our members for Mr. Finanzio? Nope. Okay. All right. Well, that brings us to a close for today. But before we close, I just wanted to check in on questions on notice and timetabling issues. So from the proponent, I've got on my list so far some sort of schematic of the treatment plant, which just gives us an indication of how big it is and so forth. And clarification of the purpose of that mixing zone at outlet W3. From the EPA, we have a question on notice about the bubble limits for the refinery. And
Bubble limits or stack specific limits?
Existing stack.
Stack specific limits on the refinery. And from DECA, if Ms. Cluning is still on the line, we had some drafting on the triggers in the EMF, how she wants to see those incorporated, plus that issue about the threatened and migratory birds. On timetabling issues, Mr. Townsend, what are you proposing in terms of your topic-specific submissions? Because the timetable that we issued last week, which is now 3 steps behind where we are, had a day and a half for submissions from you at the end of next week. That's not going to work with the way that the evidence is going to be led. Are you proposing to present a topic-based submission at the start of each new topic of evidence?
Thank you. Sorry about that. But we had anticipated, I thought this morning, that the expectation would be that after the evidence, including the marine, you would get a substantive submission from us. We didn't think it needed a day and a half. That would have been next week, but we figured that perhaps when you hear from us the first day back in Geelong, you might want to give us 5 hours or something like that.
Okay.
That would be more comprehensive based on the evidence, including cross-examination. So any topic submissions between now and then were more of the nature of what I showed you today, introducing the witness and showing you the mitigation measure, but not discussing the evidence as such. So we had in mind that get through the marine evidence next week, come back, give us a few hours, or you can on that day. I understand the others would prefer we gave our submission at that point. We could have less for our ultimate reply. I think you've given us 3 hours for the final reply. We probably don't need that long, given that we'll be doing a substantial submission. So we thought you might find us time there, and that would be based on the evidence, of all the topics. If that was okay, while I'm just talking, it still leaves. Well, can I jump in on Aboriginal cultural heritage, or the underwater Aboriginal cultural heritage?
Yep.
I think Ms. Solveraj mentioned there might be an opportunity to have an in-camera session this Friday. I can certainly be available for it. I can't yet guarantee I can get Mr. Coronius, but I wondered, and we can come back to you on that tomorrow. But in the interest of keeping the timetable moving, I wondered if an option would be, if there were questions that I can get answered, perhaps we could keep the time as an option. But I'll be able to let you know tomorrow. We just need to speak to him. I know he moves around a bit. It's just difficult to, at this stage, to say I can get him there on Friday. But we want to hang on to the time.
Okay.
So can I come back to you on that one tomorrow, but proceed on the basis that one way or another, you might slot in that hour on Friday.
So we're looking at 12 noon
That's
for the
fine.
hour on Friday?
Yeah, it's fine. It's just, I've just got to clarify for you whether I can get that help, or whether you'd be assisted if we didn't do it, if we can get you answers in writing, if that's okay. But we'd love to keep that time, because that makes next week look quite realistic about the marine evidence. We come back 5 hours day one, and you can reduce our reply time, which was 3 to, it gives an hour and a half or something.
That sounds great in theory, but there's a whole lot of things that have to happen between your submission and your closing submission.
What, there are other people in this case?
So what we were where we were heading was so at the moment, we've got the school giving 3 hours of submissions on Monday, the 13th of January. We were going to shift you to the afternoon, and we'll just have to sit a long day there. So we don't want to take away from your 3 hours. So we're proposing, if we can find gaps that are opening up in the timetable as other submitters are dropping out, we're trying to put our afternoon submitters for the 13th into those gaps, give the school the afternoon from, again, my timetable says 2:30, but we'll give you from 2 till 5, so you get a 3-hour block in the afternoon, which would give us a 3-hour block for the proponent in the morning, but 5 is a big ask.
Well, can I be heard on the sequence?
Yes.
In a sense, we're the main contradictor, and the way that the sequence goes at the moment, you've got the EPA coming after us, which we might want to have a say about. It did seem to us that when the opportunity, friends, I think, will need some time to close. They've said they can do it in 3 hours, but maybe they can. What I was going to suggest was that we move to another day, and so that we've had the opportunity to hear them and the EPA and then put our submissions in totality. Otherwise, what you'll be doing is hearing them and then us on the same day, which is a very long day and in the middle of summer.
Yep.
True it is that we'll be closer to the beach than we are today.
Are you aware of what the swell's going to be doing?
I couldn't, but there are some people on this other list here who I know. I think the surf riders will be able to tell us.
Open to that. The challenge is finding you
Another
a
slot.
slot.
Can you leave that with us rather
Yeah.
than lock it in now? It's a way off into the future.
It is a way off into the future, but we, you know, in the interests of forward planning, we've had a discussion amongst ourselves as a committee. And jump in if I got this wrong, guys, but the week before the 13th of January is no good for us. The week after the 13th of January, I wrote this down somewhere on one iteration of the timetable that I had this morning. Everything except Tuesday afternoon. Yeah, so from the 20th through to the 23rd, the committee is free and available except for Tuesday the 21st in the afternoon.
That's the following week.
That's the following week. So we'd have to either extend the booking at Waterfront or I think the PPV room, one of those might be available if we needed it.
Am I right in saying that you're also reluctant, having published this timetable and given members of the community times to shuffle them around too much?
Yeah.
Yeah.
The problem that we've got, and it's a logistical problem, but we've got 60 odd submitters that we've got in 3 days, and shifting them all now.
No, I get that. Could you leave this question of submissions with us?
Yes.
With council?
Yeah.
So that we can talk about it, because it might be that week we just use, but anyway, I won't preempt the discussion.
Okay, we'll revisit tomorrow morning.
Yes, thank you.
Okay. Anything else anyone wanted to raise before we finish for the day?
Only one thing. I won't be here for all of the case. I'll be moving in and out as I did the last time. Ms. Collingwood will have the carriage of the matter when I'm not here. That might be for the witnesses tomorrow.
Yep. Okay. Well, we'll see everyone at 10 o'clock tomorrow morning for Mr. Rolling's evidence. Thanks, everyone.
Thank you.